morning. How are you, Al?
Good morning.
Good morning.
Um, is there a court reporter? Miss Kimberly, can I have your phone number?
Yes. My cell phone number is 954-918-2403. I'm with United Reporting.
Thank you.
Mhm.
Um, Counsel for the plaintiffs, can I have your witnesses?
I'm sorry?
How many? Can I have your witness, counsel for the plaintiff? The name?
I'm the pro se plaintiff. The witnesses I was planning on calling are myself.
Uh-huh. Okay. Depends. Do you have any witness?
Yes, we have Captain Raymond Dijon of the City of Homestead Police Department. And depending on testimony of the plaintiff, there might be a rebuttal witness.
Okay. Thank you very much. Good morning, Judge.
Good morning, Alba. Thank you for being with us.
Welcome.
Good morning, everyone.
Good morning, Your Honor.
Okay, and we're here for the trial. Do you have the style of the case, Madam Court Reporter? Dr. James Eric McDonough versus Eric Stetton, Samuel Seskind, Weiss, Sirota, Cole, and Bierman, and the City of Homestead.
Yes, I
and
do.
there's another plaintiff. Photography is not a crime.com.
Okay. Thank you, Your Honor. I do have it. Thank you.
Okay. All right. Thank you. All right. And I've had a lot of incidents of Zoom bombing. So I see that there's somebody by the name of Grant Stern. I just need to ask you to identify yourself.
My name is Grant Stern. I'm a journalist. I asked permission from Eunice Singler to make video recording of this proceeding.
Okay. Very good.
Good morning, Your Honor.
Good morning. Welcome. Okay. So I guess Dr. McDonough, since you're the plaintiff, do you wish to give the court an opening statement before
Yes,
we
ma'am.
go
I have a
into
short
the
opening
testimony?
statement for you.
I'm sorry, you have? Yes?
Yes, ma'am.
Go ahead, please.
Your Honor, we're here today because defendant City of Homestead has a pattern of unlawfully withholding public records through a myriad of schemes. Two of those schemes will be demonstrated here today. In the first method, defendant City redacts video of uniformed police officers by claim of an inapplicable exemption. This creates excessive charges, unjustified delays, and an affirmative refusal to produce all non-exempt records. In the second method, defendant City overbroadly interprets public records requests, inflating the number of hours required, and charges for costs not actually incurred or required to be incurred by the city. And this creates excessive fees and costs to produce non-responsive public records and inhibits the rightful access to public records. The above violations are affirmative unlawful refusals under the law, and the requested declaratory and injunctive relief is supported by the evidence. Further, under the law, I'm entitled to all reasonable costs of enforcement here. Lastly, the record suggests that City plans to accuse me of fraud and conspiracy and to argue an improper purpose, but this is only done to obfuscate the issues. However, it is City's invoices which are fraudulent, and City's argument based on such false allegations has already lost in case number 19035962, and any continued argument to that extent should be barred by collateral estoppel.
Thank you. Okay, and Mr. Mandel, do you wish to provide the court with an opening?
Yes, Your Honor. Also, just for bookkeeping purposes, there have been stipulated exhibits that I discussed with Dr. McDonough prior to today. So I guess when we get to the evidence portion of the trial, we'll go over that with Your Honor.
Okay, very good.
I'll make reference to some of these during my opening, which I won't be as brief, but I'll hope to be brief. Your Honor, this case was filed almost 6 years ago, relating to initially 3 public records requests out of over 100 different public records requests that the plaintiff has submitted over the past few years to the City of Homestead. He amended his complaint, added 6 or 7 additional public records, added the city manager as a defendant, the police chief, the city clerk, various attorneys. The matter was initially with Judge Rabull. Judge Rabull dismissed on May 21st, 2018, several claims, told the plaintiff basically to clean up his complaint. And instead of doing that, the plaintiff on June 18, 2018, served a 60-page second amended complaint, naming 8 lawyers in my firm, including me, and also challenging an additional 30 different public records requests. That brought the total to about 40 different challenges within the lawsuit. He moved to dismiss it again. He amended it for a third time. Then we had a fairly lengthy hearing with Judge Rabull on October 18, 2018, where Judge Rabull basically threw out just about, I'd say maybe about 90% of everything in his lawsuit, maybe 95%, give or take, with the exception of a couple of requests. Specifically, we'll call them requests number 4 and number 6 that pertain to whether or not videos, a cell phone video taken by a Homestead police officer of the plaintiff's arrest at City Hall, and also a dash cam video of an arrest by another officer, whether the city improperly redacted the identities of officers on the video, not whether or not they produced it, whether or not they improperly redacted it. Importantly, Judge Rabull also
Let me ask you a question, because I know what redacted means when it's a document.
Sorry.
In a video, does that mean that the person's face is blacked out?
Blurred out.
Blurred
Yes.
it out. Okay. Blurred
Yes,
it
Your Honor. Blurred out. Importantly, Judge Rabull also dismissed all claims for injunctive relief with prejudice. Plaintiff then amended his complaint 4th time, so our operative pleading now is a 4th amended complaint, challenging about, again, the improper redaction of the, again, a cell phone video taken of his arrest in August of 2016, and that's called request number 6, and then request number 4 dealt with the redaction of an arrest back in 2014. He also asserted various excessive charges relating to several different requests, sought broad sweeping declaratory relief that went way above and beyond simply challenging the charges for specific requests. And Judge Ruiz Cohen heard the remainder of the claims. We moved for summary judgment back in March of 2021. It was actually March 25th, 2021. Judge Ruiz Cohen granted the city's motion for summary judgment as to everything with the limited exception of the following. And if Your Honor, I can share the order from Judge Ruiz Cohen. If you just bear with me a second, I'll share the screen. I'll pull it up for Your Honor. Your Honor, can you see the order that I have pulled up?
Yes. Order
Okay.
on City of Homestead's motion for summary judgment.
Correct.
Okay,
So
it says granted in part and denied in part. Claims relating to request number 4 and number 6, motion is denied with
Right.
respect to those 2. With respect to plaintiff's claims relating to request number 5, the motion is denied.
right. So specifically as at 4 and 6, Your Honor, it says the court shall have a hearing to determine whether the delay in providing the documents responsive to request numbers 4 and 6, which were turned over after the initiation of the original complaint, constitute an unlawful refusal and entitlement to an award of costs. Just so Your Honor knows, the unredacted versions of these videos at issue were produced to the plaintiff in December of 2018. So he's already had possession of these unredacted videos for more than 4 years already. Okay. And the sole issue is whether or not the delay in producing them in an unredacted form was unreasonable. That's one of the issues for today.
Okay. Was the delay reasonable?
Correct.
And how many months did it take for the? Well, I guess that will be part of the testimony.
I'll go through the timeline, Your Honor, and explain
go ahead.
the basis for why things were done the way they were done. With respect to number 5, that pertained to a specific request relating to all documents relating to the City of Homestead Police Department's Facebook page. Judge Ruiz Cohen found that there was an issue of fact as to whether or not responsive documents were turned over. And the second part of her order It says the court shall have a hearing to determine whether the delay in providing documents responsive to this, we'll call this request number 5, constitutes an unlawful refusal and an entitlement to an award of costs. So those are the only 2 issues that are to be tried today. Basically, the case has been whittled down just to this. I mean, I think maybe 98, maybe 99% of all the issues that were raised have been disposed of, and these are the limited issues of which we're here today. And I don't think that we're going to be here long, and I would think that the plaintiff would agree with me on that. As it relates to the videos, and I'm going to go through some of the facts, Your Honor, that the evidence will show. That on September 14th, and again, I'm going to, because I have my, let me stop sharing here. I'm going to just walk through a couple of exhibits that were stipulated into evidence. So, pulling them up. Okay. Just going to share my screen again.
Excuse me, can you please tell me, counsel, what exhibit have you stipulated into evidence?
Yes, Madam Clerk. This is City Exhibit F and Plaintiff's Exhibit 1 on his exhibit
Okay.
list, and this is one of the stipulated documents of evidence.
So on your list is F, right?
On my list, on the city's
Defense.
list, it's F, and on the plaintiff's list, it's 1.
Okay, so I let me know when it goes in. I'm putting yours in the evidence now.
Thank you.
Thank you.
So this, Your Honor, was what we'll call request number 4. This was submitted on September 24, 2014. As you can see, it was received by the city clerk on that date. And the request was copies of all documents and recording from an arrest taking place on July 10, 2014 at
And
19.
that was the arrest, does it mention the arrest of whose arrest, or?
It doesn't mention who the arrest on the request itself. It doesn't say who it was, but it was.
Can you make the document a little bit bigger, please?
Sure. I'm sorry. Fairly large screen.
Okay, it says copies of all documents and recordings for arrest taking. Oh, so it identifies the arrest by the hour, not
By the date and the hour.
Date and the hour, and the officer making the arrest, but it doesn't provide the name of the person who was arrested.
Right.
Okay.
He's not just seeking the video. He's seeking all documents, including the dash cam footage, the radio records, dispatch records, the A form, which is the arrest form, the incident report, transport documents, notes, phone, etc., to include every public record relating to the arrest. So it's not just the video. He's seeking everything.
I see that.
Then on October 10th, the city responds with an invoice, and it's not just for purposes of the video, it's for everything. And
right.
in the invoice, which is City Exhibit G and Plaintiff Exhibit 2, the city responds to Dr. McDonough and gives an estimate of $441.95.
Okay.
Plaintiff never paid the deposit, so the request, the documents were not produced. I'm going to take you to request number 6, which relates to the cell phone records pertaining to the plaintiff's arrest on August 24th, 2016. The arrest was on August 24th. The request was on August 28th. And I'm looking at City Exhibit H, Plaintiff Exhibit 8. And the highlighted portion, it was actually a fairly exhaustive list of documents asked, but
all right, so that says the video footage.
Correct. So specifically, he's seeking the video footage taken by the plainclothes officer who was recording this incident with his cell phone, and any other footage that was recorded by any of the dozens of HPD homes, the police department officers.
All right, so now this is for a different arrest, because the other one, this is a
Correct.
different date here, 8/20.
The arrests in 2014 pertain to a third party unrelated to this incident.
Okay.
The arrest that he was seeking in 2016 was his own arrest. He was actually arrested at City Hall, and he's seeking cell phone footage that was taken by a plainclothes officer of his arrest in August of 2016. The city responds on September 9th, so just about a week and a half later, with an invoice. This is City Exhibit I, Plaintiff Exhibit 9. And these are all stipulated exhibits. And the deposit that was asked for was $91.24. And plaintiff did pay. And on about November 28, 2016, the plaintiff received the records. The video was redacted of the identities of the officers shown in the video, but all the other records were in fact produced.
Okay.
It wasn't, this lawsuit initially, Your Honor, was brought in July of 2017. The videos that we're talking about, request 4 and request 6, were not added to the lawsuit until March of 2018, when he filed his first amended complaints. Interestingly, prior to amending his complaint, we know that the plaintiff already had possession of his arrest in an unredacted form. We don't know how he got it, but we know that as of October 28th of 2017, and we sent him a request for admission, he had that unredacted video. In fact, he posted it on his own website, or his Facebook website known as True Homestead. Regardless, the city moved to dismiss the claims as related to both the videos. And the basis that the city moved to dismiss on was the fact that there's a public records exemption, 119.071, paren 4, paren D, 2.A is an apple. It basically says that the home addresses, telephone numbers, social security numbers, dates of birth, and photographs of active or former or civilian law enforcement personnel are exempt. And the city reasonably relied upon this interpretation of the statute to redact or blur the identities. Mr. McDonough argued that this section only said that it protected the identities of the officers because it was photographs. But he's like, I didn't ask for photographs. I asked for videos. And this doesn't include videos. But the city's interpretation of that is, if it doesn't include videos, then the statute is basically meaningless, because you could just simply circumvent the exemption by asking for a video. We think that videos are far more revealing of an identity of an officer than even photographs.
So the city interpreted it to mean an image, whether in photograph form or like
video. Correct, Your Honor. We didn't. The interpretation of it was that if you don't apply it to video, the statutory exemption is basically rendered meaningless. It's a meaningless interpretation, just to say it applies to photographs and not videos as well. So the city again moved to dismiss on that basis, and in granting our motion to dismiss in November of 2000, actually the order was on November 1st, 2018 by Judge Rabolt. The argument was on October 18th. Judge Rabolt did not dismiss it, and his trepidation, and the transcript reveals that he said, look, I hear you, but the legislature knows the words video versus photos. and they could have put videos there as well. So he denied our motion. I argued that it would have given it a meaningless interpretation to do that, but he says, look, I'm the judiciary. I'm not here to, to interpret or to not interpret, to redraft the statute. That's the legislature's job. Obviously, I respectfully disagree with that interpretation. That could be an issue on an appeal at some fine day. However, as a result of that ruling, Your Honor, which was again November 1st, 2018, and in an abundance of caution, the city just at that point produced the videos within the next month in an unredacted form. It was the first time that we had a ruling from the court on the issue about whether or not this exemption applied to videos. And again, once Judge Rabull made his ruling, we heard that ruling, and then within the next month, within the next couple of weeks, 6 weeks, we just produced them, just in abundance of caution. But up to that point, the city had, in good faith, been under the legal belief, and we still do actually believe that the statute applies to videos as well. But just to mitigate any potential claim that the city has been unreasonable here, once we got Judge Rabull's pulse, so to speak, on the issue legally, we just produced them. So it was not, and the city posits, it was not an unreasonable delay. We argued it until we got a ruling, and then once we got a ruling, we produced it. I'm going to now move on to what we'll call request number 5, which it's City Exhibit A and Plaintiff Exhibit 12. And I'm just going to pull up my screen, and I'll make sure it's large enough for Your Honor to read. Just bear with me, please. Your Honor, can you see my screen?
Yes, I can.
Okay, I'll blow up the.
Thank you.
See the handwriting of the request?
Yes, now I can read it. Yes.
Okay. So the salient request here is number 1, or at the beginning, right where it says request, copies of documents and records related to HPD, Homestead Police Department's Facebook page. There's a bunch of sub-points that are really just questions. They're not asking for specific documents. He wants to know who controls, monitors, deletes the Facebook page. Well, number 2 is actually a document request, rules, regulations, guidelines established for updating and deleting content, controlling access to posts, comments, likes. He also wants an order of whose orders or directions were my post deleted or an access denied. Again, it's a question, it's not a document. Number 4, what is the legal justification for such deletions? Question, not a document request. 5, why have entire posts, not just comments, been taken down? Again, a question. And number 6, why was the review section taken down? He was apparently unnerved by some of his comments being hidden on the City of Homestead Police Department's Facebook page. And he was asking a bunch of questions, but under 119, the city doesn't have an obligation to answer the questions, just produce the documents that were requested. And it was a fairly broad request when you look at it, because it's copies of documents and records related to HPD's Facebook page. That is an extremely broad request. And under 119, we have to interpret it as a broad request. The law requires us to do that. So the city interpreted it as anything, basically, and everything relating to the City of Homestead Police Department's Facebook page. So the city provided an invoice. This is City Exhibit B and Plaintiff Exhibit 13. And when looking in particular at the City of Homestead Police Department's Facebook page, I mean, you're talking about all types of stuff. There's what they call metadata, there's posts, could be emails, could be anything and everything relating to the Facebook page. So a very broad request yielded a very broad and expensive estimate. And the estimate that was given to Dr. McDonough was an estimate of $5,159.55. And that was sent to him on April 1st, 2015. Well, Dr. McDonough said, that's not what I want. I don't want all that stuff. I don't want 53,000 Facebook records. What I want, and he narrowed it, and I'm going to go to City Exhibit C and Plaintiff Exhibit 14. Let me just pull this up. Again, another stipulated record. And he says, I'm going to look at the bottom line. I did not ask for, nor do I want, a copy of 53,000 Facebook posts. He specifically, what he wanted are these first two things. If you have records on Facebook, I would like the destruction logs for the deletions of my comments on the Facebook pages of HPD, the city, and the mayor. I would also like a copy of the policy allowing for the deletion of critical comments. So he has now narrowed his request to destruction logs and the policy. So the city, and this is not in evidence, he did not stipulate to this, but the city sent an email. This is City Exhibit E on June 15th. And by the way, he had amended his request. That was June 2nd of 2015, that prior email. June 15th, which is 13 days later, Elizabeth Sewell, the city clerk, sends to Dr. McDonough, whose email address is phd2b05@gmail.com, responding to those two limited requests that he's narrowed his request to. In regards to your public record request for the destruction logs, for the deletion of your comments on the Facebook pages of the Homestead Police Department, the city, and the mayor, there are no destruction logs because no comments have been deleted from the city, police, or mayor's Facebook pages. So we don't have any documents responsive to that request. The second narrowed request, in regards to your request for the policy allowing for the deletion of critical comments, the city does not have a document that is responsive to that request. So the city has responded after he narrowed his request promptly. We don't have these documents. And under 119, there is no obligation to create a document where none exists. So we've responded to him. There are no documents responsive to your request. That's where this issue ends. And that's really the case, Your Honor, in a nutshell. Those are the only issues we're here on. I know Dr. McDonough, he did a trial memo, and again, expounding upon all these other issues and things that have already been disposed of. And certainly I know he's going to raise a lot of these issues, as he has a right to, on an appeal. But for the limited purpose of today's hearing, are really just narrowed to request number 4 and 6, whether or not we're reasonable in the production of the unredacted videos, and this issue about the Facebook request.
I'm sorry, the issue about the delay in getting and what was the other issue you said?
And the other issue is whether or not we properly responded to his narrowed public records request regarding the Facebook issue. And as again, the evidence will show that all issues that the city acted reasonable with respect to the videos, and with respect to the Facebook request, he had narrowed the request, and we properly responded, and we didn't have anything in response. So we believe that we're entitled to a judgment in our favor as to those issues.
Okay, very good. Thank you. All right, if you could take the screen down, I'm going to turn it over then to Dr. McDonough, and you can begin the evidentiary phase of the trial and evidence to the court.
Your Honor, real quick before I start my evidentiary phase, I'd just like to rebut one important point made by Mr. Zeskind. At the October 18th, 2018 hearing on the city's motion to dismiss.
Mr. Mandel.
Mr. Mandel, I'm sorry.
Okay. I just wanted to make sure I had the name right. Okay, Mr. Mandel. Because there is a Zeskind named in the lawsuit who works for the city of Homestead, right?
Actually, that Mr. Zeskind is my law partner.
Oh,
He's
okay.
Also,
So he works for your law firm. Okay, sorry.
Yeah.
Sorry about
And
that.
he's
I noticed that his name appears on the lawsuit. Samuel Zeskind.
Just real quick.
Oh, I see. It comes right after City of Homestead, not before. Okay, I got confused. Thank you.
Your Honor, just so that we're clear here, I don't know why it keeps popping up on the style of the case. Eric Stetton also is one of my law partners. Really, the only defendant that still remains in the lawsuit.
The City of Homestead.
That's correct.
Okay. Okay, gotcha. Thank you. Okay. Thank you, Mr. Mandel. Okay, go ahead, Mr. McDonough. I mean, Dr. McDonough.
That's fine. Your Honor, what I was saying is I take issue with many of the statements made by Mr. Mandel, but particularly I take issue with his statement about Judge Rebel's dismissal order and dismissing all the claims for declaratory injunctive relief. If I could share my screen, I would like to show the order that came from the October 2018 hearing. Let me see if I can get this to work here. Okay, can you see my screen, Your Honor?
I can see it perfectly.
Excellent. So here's the order. And
okay,
as
order
you can
and a judge. All right, let me see. For the reasons stated in the motion and on the record, the city's motion is granted in part and denied in part. With the exception of the claims identified in paragraph 3 of this order, the claims brought against the city and plaintiff's third amended complaint, including but not limited to the claims for declaratory injunctive relief, are dismissed with prejudice. Okay, so with the plaintiff claims against city relating to request 4 and request 6, as they are identified in the third amended complaint, are dismissed without prejudice, which means that they were dismissed, but you were given, I guess, leave to amend. Plaintiff's claims against the city relating to alleged overcharges are likewise dismissed without prejudice. Plaintiff shall have 10 days from the entry of this order to file a fourth amended complaint, which shall include only the remaining claims identified in this paragraph. Okay.
What's important about this, Your Honor, is contrary to the allegations of Mr. Mandel, the declaratory injunctive relief claims for request 4 and 6, which are the videos, and for overcharges, which include request 5, were not dismissed with prejudice. I wanted to make that very clear. Mr. Zeskind keeps trying to spin this order around.
Hold on, because, okay. Okay, so the plain reading of the order, in number 2, it says, with the exception of the claims identified in paragraph 3 of this order, the claims brought against the city in plaintiff's third amended complaint, including, but not limited to the claims for declaratory and injunctive relief, are dismissed with prejudice. Okay, so yes, the deck action and the injunctive relief were dismissed with prejudice. With prejudice means that you have no leave to amend.
I understand that, Your Honor, but it says with the exception of the claims identified in paragraph 3. So
well,
I read that to be the claims in paragraph 3 are accepted from that dismissal.
No, that's not what it says. So in paragraph 3, it says in relation to request number 4 and request number 6, okay, that those claims are still active, which is what Mr. Mandel properly identified to the court, that there is the issue of whether or not the city of Homestead acted as required by law under the public records to those particular requests, number 4 and number 6. Okay, so that is still in play, which is exactly what Mr. Mandel stated.
Well,
injunctive relief and declaratory relief are off the table.
But Your Honor, I had claims
the city of Homestead's the response to your request number 4 and number 6 are what are still in play.
Yes, ma'am, Your Honor, but I had claims for declaratory injunctive relief for requests 4 and 6 as well.
No, no, no.
In the,
But that, yes, but it's very clear to the court that
okay.
it's that declaratory and injunctive relief were dismissed by Judge Rabol.
Okay.
And what is left are whether or not the city complied with request 4 and 6. That's what I believe, that there was no misstatement on the part of Mr. Mandel. After reading the order, I am convinced that he represented the order to the court accurately.
Okay, Your Honor. I respectfully disagree, but I won't belabor the issue.
Okay. All right. So let's go into the presentation of evidence.
Yes, ma'am. And again, before I get into my evidence, I would ask if I could reincorporate paragraphs 16 through 35, 53 through 57, and 63 through 77 of my verified Fourth Amendment complaint. And those are the paragraphs that are related to request 4, 5, and 6.
Okay. Yes.
And as Mr. Zeski noted, I filed a trial memorandum, and I filed it with the court, and I served it. I would like to incorporate that as part of my case, or if not, as part of my closing.
Anything that you have turned over to Alba in advance of the trial and submitted as evidence, as long as there's no inadmissible hearsay contained in the documents, the court will take judicial notice of.
Okay, this was just a memorandum, not exhibits or evidence, Your Honor.
Okay.
And the one last thing before I start is I would like to hereby move to introduce into evidence exhibits 1, 2, 8, 9, 11, 12, 13, and 14, which have been stipulated to by the defendant.
Okay, very good.
Yes.
And Alba, do you already have those exhibits?
Could you? Yeah, I have them. Could you repeat it? 1, 2, 8, 9.
Yes, ma'am. 1, 2, 8, 9, 11, 12, 13, and 14.
Thank you.
Yes.
I'm so
Stipulating
sorry.
just,
I had to leave a second. So what was the other question?
and just so that, and it's stipulated.
I can give you his social.
Hello? And that they correspond
Okay,
to the city.
I'm under Miami.
I don't know.
Yes. Okay.
They correspond to the city, following city exhibits, in the same order that the plaintiff read them out. Plaintiff exhibit 1 is city exhibit F. Plaintiff exhibit 2 is city exhibit G. Plaintiff exhibit 8 is city exhibit H. Plaintiff exhibit 9 is city exhibit I. Plaintiff exhibit 11 is city exhibit J. Plaintiff exhibit 12 is city exhibit A. Plaintiff exhibit 13 is city exhibit B. And plaintiff exhibit 14 is city exhibit C. All those have been stipulated.
Okay. All right. So yes, Mr. McDonough, those are all moved into evidence.
Excellent. Thank you, Your Honor. Okay. On July 24th, 2017, I filed an instant action in this case, which contested public records request 1, 2, and 3. On July 31st, 2017, this court held an immediate hearing, and defendant was ordered to produce records responsive to request 1 and 3. And with respect to request 2, production of the responsive records was waived, but only after the defendant had admitted that the records responsive to the request filed by a third party, Mr. Jensen, were identical to my request 2.
Your Honor, I'm going to object. This is the evidentiary portion. He's not under oath, and also, just if I may, Dr. McDonough,
Okay.
and also, to the extent that they're dealing with issues that are not related to 4, 5, and 6, I'd also object on relevancy as well.
Okay. All right. So first of all, if Mr. McDonough, if you're going to switch from argument to testimony, then it does have to be sworn testimony. So Mr. Mandel is correct. Alba, I need you to swear in Dr. McDonough.
Can you please raise your right hand, sir?
Yes, ma'am.
Do you swear or affirm that the evidence you're about to give will be true, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Thank you.
Okay, all right, so Mr. McDonough, because the my predecessor judges have disposed of the other issues, let's just let's keep the testimony within the, related to the requests that are still in play, which are requests 4, 6, and 5.
Yes, ma'am, Your Honor. The majority of my testimony today is going to be directed to 4, 5, and 6. I just wanted to
Good.
note that the city
Oh, you just wanted to give me some background.
that the city
Okay.
had to produce records 1, 2, and 3, and production of records after the filing of the lawsuit for purposes of cost is an unlawful refusal, even if it's not declared to be an unlawful refusal. I have that in my memorandum. I just wanted to show you the order for that real quick to show you how they were ordered to give me the records, if you'd like to see it.
Sure, go ahead. You can
Okay.
show it.
So let me get this real quick. Give me just a second. Let me see if I can share this. Okay, Your Honor, this is the amended order that came from the immediate hearing from July 31st, 2017.
Okay, it is hereby ordered in a judge regarding the November 2nd, 2016 request. The city will provide within 10 days electronic version of responsive documents regarding the June 9th, 2017 request. The city, there's a period. Regarding the June 9th, 2017 request, the city has provided hard copies of responsive documents. Regarding the June 5th, 2016 request, plaintiff has stipulated that he has received the documents, but reserves the ability to challenge the cost estimates at a future proceeding. Okay. Plaintiff also may bring an action for injunction regarding any alleged delay in document production. The city will provide plaintiff and file with the court a list of the hourly rates for records production. Okay.
And the relevance of this, it just goes towards the cost, Your Honor. So I would like to move to enter this exhibit into evidence. This is my exhibit number 16.
Okay.
First of all, I object, Your Honor. I think that this has nothing to do with any of the issues that are to be tried here today. This deals with an initial hearing back in July of 2017 relating to requests that have nothing to do with why we're here today. And again, all issues.
All right. Well, Mr. Mandel, the only relevance that I see right here and with this order is an acknowledgement by the court that the police department does charge an hourly rate for production of documents, and that is part of the order. Now, the only thing, as I see it, for this court to determine is whether or not it was reasonable. But I think that it makes clear in this order that there's a charge, an hourly charge associated with producing these records.
Your Honor, I don't think that the cost issue the cost, the labor to produce the documents have anything to do with the issues today. The issue is the delay, or the delay in producing the videos, and whether or not the delay was reasonable, not whether the costs themselves were unreasonable. Because at the end of the day, he has received the videos in an unredacted form. By the way, at no cost to himself. Those were produced without him. He didn't pay a penny for the unredacted videos. Those were all produced on their own.
Okay.
I object, Your Honor. I paid for the videos.
Excuse me. Let me. This is part of my objection, Dr. McDonough. Let me just have my say, please. But the videos were produced, and again, the order from the last order from Judge Ruiz Cohen that framed the issues to be tried is whether or not the delay. So, of course, the order, and Your Honor could take notice of any order that's been issued in this
Of
case,
course.
but obviously it doesn't need to be put into evidence. However, I don't think that any of the issues that relate to a prior order from the court relating to unrelated requests and the issues relating to those requests which have been disposed of in favor of the city need to be relitigated again, and therefore it's irrelevant.
All right. Well,
Just,
the court's going to take judicial notice of all previous orders entered into by the predecessor judges, and whether or not the what was ordered and adjudged in those prior orders is relevant to the remaining issues will be determined by the court. All right, Mr. McDonough,
Yeah.
why don't you take down that order and continue with your presentation?
Yes, ma'am. And just to clarify, Your Honor, the reason I wanted to show that order was to show proof that the city produced records after I filed the request with respect to requests 1, 2, and 3. I know that any claims related to declaratory injunctive relief for those are gone off the table. And
Yes.
And that was an order, but it wasn't a final order. And I wanted you to be aware of this because it goes very strongly towards if I'm entitled to my cost of enforcement here.
Just for clarification, is this order in evidence, Judge, number 16?
Well, if it's an order entered into by a judge, it's going to be on court map, Alba.
So-
It's going to be part of the docket.
So put it in evidence, sir? I mean, I need to know.
Well,
if
it's already
Yeah, okay.
part of
Okay,
the
Judge.
docket.
Thank you. I just wanted clarification. Thank you.
Okay, go ahead, Dr. McDonough.
I'm sorry if I didn't follow some procedure here. I thought I had
No,
to
no,
file
go
it
ahead.
as an
It's
exhibit,
fine.
so I had it as an exhibit. So Your Honor, the initial complaint was filed on July 24th, 2017. On March 14th, 2018, I filed the first amended complaint in the instant action, and it was deemed served and filed by this court. The First Amendment complaint added approximately a dozen additional requests as noted by Mr. Mandel, and this included request 4, request 5, and request 6. Stay with me. Hopefully I'll be able to save a lot of time. Based on your interpretation of Rebel's order, a lot of what I had prepared is going to go out the window, so I'm trying to eliminate that while still keeping what's relevant.
Okay.
And claims to all contested requests, except for requests 4, 5, and 6, were dismissed at the October 2018 hearing on city's motion to dismiss, or at the March 25th, 21 hearing on summary judgment, as noted by Mr. Zeskind.
and
So now we get to request 4-1. On September 24th, 2014, I submitted request 4-1, which asked for records including dash cam footage of the arrest of Maria Salado that took place on July 10th, 2014. And the exhibit for that has been stipulated to by defendant, but I would like to share that with you again.
Go ahead.
And as Mr. Zeskind, or Mandel, I'm sorry, it's normally Mr. Zeskind that's litigating against me, and so I'm used to that. Matt, no offense to you, I apologize.
you're good, Dr. McDonough.
There's been 7 attorneys litigating me on this case, so I get confused sometimes trying to keep track of all of them. It says copies of all documents recording for the arrest taking place on 7/10/2014 at 1936 hours by Officer Merguido. This includes dash cam, radio records, dispatch records, A-form, incident reports, transport documents, notes, phone, etc., to include every public record related to the request. I wrote this broadly because I wanted to get all the documents related to the request. I believe there was dash cam video and a police report and an A-form. I don't believe there was anything more than that. So I will go ahead and this has already been entered in evidence. I'd like to stop sharing, and now I will bring up my Exhibit 2, which was also stipulated to, which is the invoice related to this. And here we can see the invoice. There's a charge for
So
17.
it says police staff time 17 hours at $24.91 per hour. And then this production of the CD, and I guess there's 15, I guess, cents a page for the copying. Okay, I see it.
And so you see the amount for the time. I also like to note that when I filed the request, I specifically asked it for electronic copies, and they're giving me paper copies and charging for paper copies. I know it's not a big charge here. Some requests, there's $100 or more charge for paper copies when there's electronic records. And also at the July 31st, 2017 hearing, Judge Bailey noted that producing paper copies.
Okay, but in this, okay, but let's just for the what I'm seeing is that there were $2.25 were charged for the paper copies. So really the bulk of the charges, specifically $429.70, were related to the manpower charges. I will call them manpower, or the time spent unearthing, locating all of these records.
And I'll agree with that, Your Honor. And the 225 is not a great charge, but I do believe it's an unwarranted and excessive charge. More importantly, as noted by Judge Bailey at the immediate hearing in this case, when they produce paper copies of the records that are electronic records, metadata is lost. I wanted to note that. And I also want to note that they're charging $5 per CD, and costs are required to be costs directly incurred by the city, and it doesn't cost $5
Well, it
per
says
CD.
it's quantity 2 CDs, so it appears that okay, 2 CDs, right, and it's $5 per CD, and that's how it ended up to be $10. Yes.
Yes, ma'am. So I wanted you to pay attention to those costs because I was going to argue those in my closing. Okay. And I'd also like to note that the city has a policy of waiving the first 30 minutes of time when responding to public records requests, but they did not waive the first 30 minutes here.
Okay.
Okay, I'll stop
So
sharing.
in other words, if they were charging $24.91, it sounds like what you're claiming is that there should have been a reduction of roughly $12.45.
Yes, ma'am, Your Honor.
Should have been reduced from the hourly rate.
And even though the city has this policy, they have a pattern of not waiving the first 30 minutes in my records request.
I'm just going to object. I think that mischaracterizes the document. It's 17.25 hours, and the rate is something else. He was talking about reduction of the waiver of the first 30 minutes. I think there's confusion on the, and I'll object on vagueness and on that description of the document.
Okay. So
And I'll note in discovery, I asked the city for any records they had of how they calculated this time, and they were not able to produce any. And other records requests where they have waived 30 minutes, it says first 30 minutes waived.
Well, I mean, I don't. So I guess time is time, right? I guess the staff that prepare these, that do this labor, provide their time, and then they calculate an hourly rate on that time. I'm not sure. In other words, I'm not sure how they are supposed to respond to how time is calculated. I mean, time can only be calculated one way: how long it takes somebody to do something.
I understand, Your Honor. And another important point here is the majority of this time, as I'll show in just a second, is for the redaction of videos.
Okay.
So I'll stop sharing this. And I want to bring up my... Now, just so you understand, there's two requests here. One was done by me. One was done by a third party, Miss Maria Salado. And so I've titled them 4-1 and 4-2. 4-1 being my request, 4-2 being her request. This is a request that she filed with the City of Homestead. And you can see that she asked for the dash cam for that arrest.
I'm going to object. It's not in evidence, and also lack of foundation, lack of predicate, lack of competence as to a request not made by Dr. McDonough, and he obviously can't speak for the city. So I'm going to object.
All right, let me ask this question. In the complaint, was this included in the complaint?
Yes, ma'am, Your Honor.
This was included in the complaint.
This exhibit was in the complaint, and it was described, and the complaint was verified as well, Your Honor.
All right, so I'll allow it.
And I got this copy from the city. You can see where it's stamped, received by the city clerk.
Okay.
So she's basically refiling my request. The arrest was for her, not for me. She had asked me if I could get records requests for her, so I filed my records request 4-1. They gave me the bill for $400 and some odd. I refused to pay. Miss Salado then on her own filed request 4-2 asking for the dash cam. And I would like to move to enter this exhibit into evidence, and this is my exhibit 3.
Okay, so what I'm seeing is your request, of course, had asked for a number of items. Hers only asked for the dash cam.
Yes, ma'am, Your Honor.
Okay.
And please note my objection, Your Honor.
And I would like to now share my exhibit 4, which is the invoice for Miss Salado's request. This came from the city.
Okay, so there's something significant that I see here. Video file was redacted for prior public records request. So once the labor was done and the video was redacted, to give an extra copy to Ms. Salado would take very little time.
I agree, Your Honor, and you can see and I was going to point that note out to you myself, which is the main reason I wanted to share this exhibit. And you can see that her total is 13.
So that you're right. So you're showing this to the court to show me that the bulk of the 17 hours was for redacting the video because
yes, ma'am, Your Honor.
You know, in this, and I don't know how many other records. You said there were some other records produced besides the video.
Yes, ma'am. I had asked for like the police report, the A form, and those other records. They're electronic records, and they could be pulled in a matter of minutes.
So the paper records that you got were what? What did you get?
I never received paper records in this case from them, Your Honor. Okay. I didn't pay the invoice, so they didn't provide any records.
Okay.
What I'm trying to show is the difference between the $440 some they tried to charge me versus the $1,300 they charged Miss Salado. The overwhelming majority of that would have been for redacting the video, which I think is an excessive charge.
Okay, thank you.
Okay, just to object to this document, just lack of laying the proper foundation.
Wait, I'm sorry, Dr. McDonough. So you're saying that redacting the video is a charge that that they shouldn't charge for?
If the redaction is proper and authorized by statute, they can properly charge for it. If the redaction is not authorized by video, then the charge is unlawful and excessive.
Okay, that because the statute used the word photograph and not image, that therefore the video didn't need to be redacted, and that they were charging you money for doing something that wasn't required by law. Now, and then ultimately you did get the redacted video that you did not pay for after this came before Judge Raboul. Judge Raboul went with a strict interpretation of the statute and chose not to interpret the word photograph to mean image, and thereafter the city of Homestead provided you with the video at no cost. Is that correct?
Yes, ma'am, Your Honor. After the hearing with Judge Raboul, the city provided me. They provided the redacted video to Miss Salato. They provided the unredacted video to me after the hearing with Mr. Judge Raboul. And that's
Okay.
for request 4. For request 6, they provided me the unredacted video in December of 2018 after the hearing with Judge Raboul. But contrary to what Mr. Mandel had said earlier, I had paid. I paid for the video to be redacted, and then they gave me the video unredacted. He made comment that they gave me the unredacted video without charge. But my allegation is there should have not been in charge for the video to begin with, which I did pay. But
You did.
That's for request
Okay.
6, not for request 4. Request 6 and request 4 are very related. They're both videos, they're both redacted the same way, and the arguments are the same for both.
For request number 6.
And I plan to get into the what Judge Raboul said at the hearing, and I'll show you all that, and where the statute says image versus photograph versus video.
Yep.
And I'm not sure, but if I didn't, I would like to move to enter Exhibit 4 into evidence as well as Exhibit 3, the 2 requests in the invoice for Ms. Salato.
Sure.
Again, I just objection for the record for not laying the proper predicate or lack of foundation.
All right, I'm going to allow them to come in to show. I mean, what I see that's significant about it is the note on there that makes reference to the fact that the video that they were providing to her had already been redacted, and that therefore she wasn't charged for that.
I'm not objecting to the relevancy. I'm just objecting that it's not an invoice that he generated or he received. It's all based on hearsay as well, and it's not. There's no proper foundation.
Any hearsay contained in the document, the court will not.
Your Honor, it's statement for a part.
It's
from a
not
party.
a sworn document, in other words. So you're saying that that's true. It's a safe list. All right, I'll allow
the
it.
city of Homestead provided it to me. It's a statement of a party. It meets the exception to hearsay rule, Your Honor.
Okay, all right.
And
Go
for
ahead.
the record, the difference in charges between my invoice for 4-1 and Ms. Salato's invoice for 4-2 is $428.65, which is a substantial amount of money for somebody to file a records request. Okay, so I'm going to skip over a bunch of stuff because we're not going to declaratory injunctive relief. So let me find where my next part is. Okay, now we'll get over to request 6. On August 28th, 2016, I filed request 6, which asked for the records, including cell phone footage taken by Homestead police officers during my false arrest on August 24th, 2016. This is my Exhibit 8. Give me just a second and I will pull it up. Share this. Mr. Mandel had shown this email earlier. This is a records request I had. There were several things that I had asked for, particularly was number 3, which is highlighted.
Okay.
It says the video footage taken by a plainclothes officer who was recording this incident with his cell phone, and any other footage that was recorded by any of the dozens of HPD officers present and are participating in my detainment on 8/24/16. Real quick, just a point of clarification. In this request and in my trial memorandum, I said plainclothes officers, but what I meant to say is uniformed officers.
Okay.
For some reason, when I was writing this and writing my memorandum, I was thinking plainclothes not being undercover, but plainclothes could be undercover, not undercover. The importance is these are uniformed officers acting in public.
Okay.
And so I'll stop sharing this, and I'm going to bring up. Oh, so I would like to move Exhibit 8 into evidence.
Already in evidence. We are set for
You
evidence.
already okay.
Yeah, that one
That's
is
right.
already.
I'm sorry. I forgot the stipulation numbers. Let me pull that up so I have it in front of me so I don't mess up. Do that again. Okay. And let me now get to Exhibit 9, which was also stipulated. And this is the invoice for request 6.
Okay.
And I'll scroll down just so you can see the bottom. The only charge here is $91.24 for 4 hours of time. And you can see the note they write in the middle. Public records request for any and all information, including reports and video footage related to the arrest of James Eric McDonough on August 24, 2016. Also, Officer John Monaco's personnel file, including IA records and or his time roster for 7/27/16. The personnel file of Officer Garland Wright, including IA records. The personnel file of Officer C. Garcia, including IA records. And a list of all officers on duty and attending the July and August 2016 meetings. I want to point this out, Your Honor. This invoice is only for the police report and the video. The personnel files were charged to me separately later, and I paid that in a separate invoice. So
Okay.
the majority of this $91 is for redaction of the cell phone footage taken by the police officer. As I was being arrested in City Hall, in front of City Hall, which interestingly enough, we had oral arguments at the 11th Circuit last month on the First Amendment issues implicated with that. One of the police officers was recording on his cell phone. He recorded about 2 minutes of footage, and the city redacted the footage there the same way they did with the dash cam with Miss Salato's arrest by having black rectangles over top of any police officers that come into the screen. So you can't.
Do you know how long one video was versus the other?
The dash cam for Miss Salato was approximately 24 minutes, and approximately 10 minutes of that was redacted. In this video, it was approximately 2 minutes, and I'm not sure exactly how long of it was redacted.
Okay, so essentially, the dash cam video was approximately 20 times lengthier than the cell phone video.
24 versus 2.
Okay, got it. Okay, all right.
And that's already been entered in evidence. And I'd also like to note that, again, they didn't waive the first 30 minutes. And let me see. I'll stop sharing this. Oops. I thought I hit the stop sharing button.
And so that $91 you did pay for.
I did pay for that. Yes, ma'am, Your Honor. Now, as to the production of unredacted videos of requests 4, 1, and 6, on October 18, 2018, this court, during the hearings on the city's motion to dismiss, rejected the city's argument that the redaction of video was supported by Florida Statute 119.071, parentheses 4, parentheses D. And city
which is the same thing that we just were talking about as far as whether the word photo means image or is it just photo?
Yes, ma'am, Your Honor. And the city had also cited, I don't know if I'm pronouncing this right, Rames's, it's Rameses.
Ramses?
Ramses or Ramses Inc. versus Demings. It's 29 Southern 3rd, 418, Florida 5th, DCA, 2010.
Okay. So they cited that case for the proposition that that photograph, I guess, means image and not just a photograph.
They cited the case and alleged that that is what the case said, but that is not what the case said. The case related to an undercover investigation that occurred inside of a strip joint. And after or during prosecution, some of the criminal defendants got unredacted copies of video footage taken by the police officers during the undercover sting at the strip joint or strip club. And later, when I believe media filed a request to get the records, they redacted the images, and there was a fight over the redaction of the images. And it held Ramsey's that the production and discovery to criminal defendants did not waive the exemptions under 119, but it held the exemption to be under 119.07 4C, which is specifically for any information revealing the identity of an undercover police officer, not 4D cited by defendants, which just says photograph of current or former law enforcement.
All right, but I think, okay, I'm trying to think. Identification of an officer can be by name or by image. So I'm not sure that it, you know, that they, in other words, I'm not going to say that the lawyers willfully mischaracterized the holding in that case, because certainly I would say that an identification can include an identification by photograph or by name. So,
and I think Ramsey's came to the right decision, Your Honor. I just disagree with city's interpretation of the case. Okay. The exemption was held under 4C, which is any information that reveals the identity of an undercover officer. That's separate than photographs of current or former officers, which is under 4D, which is what the city claimed for their exemption.
Okay, go ahead, Mr. McDonough. I mean, Dr. McDonough.
Thank you, Your Honor. So I would like to show my Exhibit 10, and this is the hearing transcript from the October 18th, 2018 hearing in front of Judge Rebohl in this case.
Your Honor, I just don't think this is proper during the evidentiary portion. If he wants to show this as part of argument, that's one thing, but I think plaintiff, who is pro se, is conflating evidence versus argument, and I don't think that he could testify, I guess, maybe what he observed or whatnot at the hearing, but to actually just read the transcript, that's something that we can provide to the court. That's not something that should be done necessarily as part of his case in chief. So I would object on that basis.
All right, I'm going to allow it.
Okay, so let me see if I can get this pulled up for us here. So you can see it's the style of the case, 2017 017 515, Dr. James Eric McDonough versus Eric Stetton et al. Transcript proceedings from October 18, 2018. And I'm going to go and get
you can go ahead and go forward.
I just want to show you that this was the transcript, that this is it.
Yes.
So we see here, the court. Okay, so the statute at issue clearly uses the word photograph. Mr. Mandel, yes, it does. The court, right. Mr. Mandel, yes, it does. The court, actually in another case that I got reversed on, I was scolded for not following the plain language of the statute, okay? And my question is, it clearly says photograph, and there are other parts of 119, are there not other parts of 119.071 that use the words, and I'm looking at it, videotape or video signal or let's see. There is actually, I'm trying to figure out where it is, but it says photograph, videotape, or image of any part of the body of the victim of the sexual offense prohibited under the pertinent sections, regardless of whether the photograph, video, or image identifies the victim. In other words, my point being that the legislator knows how to write videotape in the same section, 119.071, when it wants to write videotape, or video, or image, or just image. And Judge Rebohl very wisely called onto this, and which is also in my trial memorandum, Your Honor. And it's not just that 119.071 4D says photographs. Within 119.071, which is the exemptions for public records, it's replete with different sections where within the same paragraph it notes the difference between video, photograph, or image. It knows the difference between video, audio, and photograph. So clearly the statute or the legislator was aware of what words to use, but did not use the word image or the word video in 119.4D.
Okay, thank you.
And one more part of that. I don't want to go through the whole 6 pages, but let me see. Now here in page lines 19 through 24, the legislator used the word image in this section. They know how to use the word image when they want to use the word. If this said image, I might agree with you that moving images are images, but live action recordings of images are images. I think he meant to say photograph or video in one of those places, but we've already had this argument, and I think Judge Rebold got it right. So if possible, I would move to enter my Exhibit 18 or Exhibit 10 into evidence.
Yes.
Okay, thank you, Your Honor. Next, I would like to share my Exhibit 11, which has been stipulated to by the city. And this is an email that the city produced to me. You can see the date is on December 20th, 2018. And it says, Dr. McDonough, below, please find a link from the city which contains the unredacted video files relating to request 4 and 6. Request 4 was filed in 2014. Request 6 was filed in 2016. The complaint here was amended in March 14th of 2018 to add request 4 and request 6. And on October 18th at the hearing, Judge Rebold dismissed their arguments. And then on December 20th, 6 weeks after, roughly, the city, without any fanfare or explanation, produces the unredacted videos to me. This is more than 4.5 years after request 4 was filed. It's more than 2 years after request 2 was filed. It's more than 9 months after the complaint was amended to add these, and it's nearly 2 months after the hearing.
Okay, so 2 months. Okay, so let me make sure I get this right. So after Judge Rebold makes a finding about the use of the word photograph by the legislature, 2 months after that, you were given the video without charge. Is that right?
Yes, ma'am. At that point, the city provided unredacted copies of both 4 and 6. The hearing was on 10/18. They produced the records on December 20. So 2 months and 2 days after the hearing. If you go by the date of the order, it's November 1st. So I guess a month and 3 weeks, but roughly 2 months. Yes, ma'am, Your Honor.
Okay, thank you.
And so this was already stipulated, so I will go ahead and stop sharing this. And I would also like to note that at least for request 4, the city denied any realistic access for the purpose of the request was filed. I filed the request because Ms. Salado was considering filing a lawsuit, and that arrest occurred back in 2013. Producing the records in 2018 is well past the statute of limitations. So I just wanted to note that any realistic access was denied. And even if the city gives me the records, my victory is still hollow because they can't be used for the point that I intended to use them for.
Okay.
And other than 119.071 4D and Ramsey's, the city has no other argument supporting its redactions. And I will move along to request 5. And this is my Exhibit 12, which has been stipulated to by the city. So here's my Exhibit 12, which is Request 5. And Mr. Mandel had shown this earlier. And it requests copies of documents and records related to HPD's Facebook page. 1. Who controls, minors, deletes, etc. 2. Rules, regulations, guidelines established for updating, deleting content, and controlling access to posts, comment, and like. Under whose orders or directions were my posts deleted and access denied or restricted? 4. What is the legal justification for such deletions and restrictions? 5. Why have entire posts, not just comments, been taken down? And 6. Why was the review section taken down? Mr. Mandel notes that these are questions and that the city is not required to answer questions. I would agree with that, but I would also state this is a misinterpretation of my request. The city or Mr. Mandel reads my request to be just copies of documents and records related to HPD's Facebook page. I did not broadly request that. The 6 statements below are questions where they don't have to answer the question, but I was proposing the records I was seeking in the form of a question. And Mr. Mandel already noted, such as like 2 is rules, regulations, and guidelines. So I was looking to see if there were any records or any memorandums of law or any policy that the city had to how they control their Facebook page. I asked for who.
So I thought, wait, because if my memory serves me, I saw a document where there was an answer from the records custodian or a female that said something to the effect of that there are no policies with regards to taking down critical remarks.
And I'll get to that. That was part of where I was going. I didn't realize that Mr. Mandel was going to provide so many exhibits in his opening. I thought the opening was just for short statements. They did send an email saying that there was no deletion logs, and they did send in the email also admitted that there was no policy that they had for.
But then isn't that responsive to your question?
That might be partially responsive to several of the questions. But for instance, 1, who controls minors or deletes? Somebody has to be the administrator of the Homestead Police Department's page. They would have a record that would state that who the administrators on the page are, and it would state what their title are, whether they're administrator or moderator or an editor. There would be a record that exists for that has not been produced.
There would be an administrator, meaning the person who actually posts things on Facebook for the department and has control of the posting. So you were looking for I'm sorry, wait, because I just want to be very crystal clear about this. You were seeking to find out the identity of the person who posts that sort of runs the Facebook page for the police department?
Yes, ma'am. I'm not sure how familiar you are with Facebook, but when you can have a personal page, which most people have, and that's your page. When you do a group or a business page, such as for the City of Homestead or Homestead Police Department or my page, True Homestead, you can have 1 or more people be administrators. And then the administrators have different levels. Like they can be a top level administrator where they can have control, they can do anything.
Okay, but my question to you was simple.
I'm sorry.
Were you seeking the identity of these administrators? Is that what you were?
Yes, ma'am. Yes, ma'am, Your Honor.
Okay, because I'm not sure that it's clear to me upon reading these questions that you were asking for the identity of the administrator.
And I'm going to get to that in a minute, Your Honor. There's a bunch of emails that have gone back and forth between me and the city that are part of my exhibits about this, where I tried to clarify. However, the law is clear that if there's any ambiguity or I haven't stated request hasn't provided sufficient specificity, the burden and duty is on the municipality to reach out to the requester, not the other way around. But I did email the city a bunch of times trying to clarify this. I also take issue with Mr. Mandel's allegation that I narrowed my request. I never narrowed my request, and I'll show that email as well that he showed, but I was asking for additional records and they responded saying they didn't exist. But I never canceled saying I didn't want any of these records. And me and Mr. Zeskine, not Mr. Mandel, went back and forth several times in emails with this where they refused to act on my clarifications. But regardless, if the city Homestead Police Department has a Facebook page, there has to be a record of who controls, monitors, or deletes. And that has never been produced. I don't know if it would exist or not, but I have to imagine and speculate that there's some memorandum or email or something that some city Homestead Police Department employee didn't just take it upon themselves to use city time and tax dollars to just create a Facebook page. There would be expected to be records. I can't prove there are not, but I can guarantee you for a fact that there are records of who would control, monitor, or delete the page. I sought those. Those have never been provided.
Okay, the identity, so you after this request, you made another request asking for the name of the administrator?
No, I did not make another request, Your Honor. I sent a clarification to Mr. Zeskine, and we went back and forth. Mr. Zeskine accused me of misunderstanding his response, and I accused him of misunderstanding my request. We had to heat it back and forth. I think it was about a 7 email chain back and forth between me and Mr. Zeskine, which I plan to show as my next exhibit.
I would just, excuse me, Dr. McDonough. I would just, to the extent that Dr. McDonough is speculating that he can't offer this as evidence, that I would just object on that basis, Your Honor. He can obviously talk about his exchange and what he knows from his own personal knowledge, but he even said, I'm speculating. So we would ask that the court, that we would object on that basis and move to strike the testimony based on speculation.
All right, I'm going to roll on that later. Go ahead.
I agree that that's speculation, Your Honor, but the city's required to either produce records at this point or to attest on the record that no such records exist.
Okay, so I just don't want to go too far afield. So at this point, I'm trying to really stay focused on what is remaining after the motion for summary judgment and the things that were disposed of initially by Judge Rabull. And I just, so as I understand it, I am, trying to stay focused on whether or not these requests were reasonably responded to, whether they were complied with in a reasonable manner. And that is, I believe, what I'm tasked to do as the trier of fact.
Yes, ma'am, Your Honor. And this is not my testimony, but I would just note for you that the city, by law, is required to either produce the records or attest that no such records exist. And that's the reason I was bringing this to you, and that's the relevancy of it.
Okay, all right.
So I'll stop sharing this. And I'm now going to bring up my Exhibit 13, which has also been stipulated to by the city. And this is the invoice for Request 5. You see it's 265 hours of estimated staff time at $19.47 per hour to review 53,000 HPD, 53,000 Facebook records for confidential exempt content and redact if necessary prior to release as a public record. Of note, at the immediate hearing of this case on July 31st, 2017, after the hearing, the city produced me full unredacted copies of the entire Facebook histories for the City of Homestead's Facebook page, the Mayor of Homestead's Facebook page, and the Homestead Police Department's Facebook page. The posts and comments on the city's Facebook page are already publicly posted, and I'm completely at a loss as to why they would need to be reviewed for exempt material. Further, I was not seeking any Facebook post or comments. As you could see, or as I explained, in Request 5, I was seeking records and documents related to administration of the Facebook page, not actually public. If I wanted to see what they put on their Facebook page, I would just go to their Facebook page and look and see what they put up there.
Okay. So, so your argument to the court is that their response with regards to your Facebook request was unreasonable.
Yes, ma'am. Overbroad and unreasonable, and excessively inflated the number of hours necessary to produce the records.
And then ultimately, when you received the materials requested, they were received on what date?
They never produced any records responsive to the request 5, Your Honor.
Oh, I thought you said that you did get all of the Facebook posting.
I'm sorry. In a separate request, I believe it was request 1. In this case, I asked for the Facebook histories of the city, the mayor's, and the police department's page, and they gave them all to me. What I'm alleging here is if they can give me the entire history of 3 pages for free, unredacted, why would Homestead by itself cost $5,100? The police departments.
Okay, so what you're okay, so I want to just be very clear. Your argument with regards to the Facebook request have to do with the charges that were initially, that you were invoiced for.
Yes, ma'am. Kind of 2 points. I feel the invoice was highly excessive and unlawful, and they have not produced any responsive records or stated that no such records exist, with the exception of them later stating there were no deletion logs and later saying that they had no policy for allowing deletion of records. Other than that, no records have been produced. No records have been produced at all, but they stated that those records didn't exist. They have not stated on the records that there's no emails, there's no memorandums for starting the page, that there's no administrators of the page. Because if there wasn't an administrator of the page, there wouldn't be a page. So it's 2 points. Excessive cost and failure to produce. And had I paid...
So they failed to name the administrator.
Yes, ma'am. And had I paid the $5,100, they would have given me records, and not a single record I was looking for would have been provided to me. So I had an issue with paying $5,100 for records that I wasn't seeking.
I'm going to check. That pure speculation. If you would have paid, then how do you know what you would have gotten?
I'm sorry, Matt, you're breaking up.
That can be part.
Objection. Speculation.
All right, I'm going to that is use that argument. Certainly, it's speculative as evidence, but it is part of his argument. All right, so okay, and Mr. McDonough, do you have more evidence to put before the court?
The last 10 or 15 seconds, my computer just froze up. I didn't hear what you or Mr. Mandel said.
Oh, as far as I just responded to his objection that I said, well, on the grounds of speculation, and I basically just said, well, that the court will allow you to use it as part of your argument.
Okay.
Okay. All right, go ahead.
Thank you for clarifying, Your Honor. I just wanted to make sure I knew what was going on there. Okay, next I would like to share Exhibit 14, which was also stipulated to by city. And this is the email chain between me and Zeskind relating to these records, request 5. Yep. Okay, can you see this, Your Honor?
Yes.
All right, so this is an email chain. I'm going to scroll down to the bottom because, email chains, you kind of got to work your way backwards. So here's at the bottom. Scrolling up, this is just the signature stuff that gets put off. So here's the response to the city, where the deputy city clerk, Patricia Sullivan, is telling me that they have 53,000 records and they want $5,159. And then here you can see this is my response to Patricia Sullivan. And you can see I say to be absolutely clear, as it appears the people at HPD are not fully literate.
Okay, and then here for the first time, I do see who controls, monitors, deletes the HPD Facebook page, because on the prior request, I did not see that you were asking, or it wasn't clear that you were asking for an identity of a person. But in here, in this email, you did say use the word who.
This is verbatim. This is verbatim from request 5, Your Honor. The things are numbered 1 through 6 here are verbatim 1 through 6.
Oh, okay, okay. You know what? I'm sorry. It was handwritten, and I'm afraid
I chicken scratch handwriting.
I didn't. I mean, did not realize that you were asking who. Okay.
And as clearly seen above, I did not ask for one single Facebook page, and so I tried to make this clear. And to be honest, back in 2015, I was not as succinct with my words as I am today. Mr. Zeskind replies back, "Good afternoon, Mr. McDonough. You requested without any time or other limitations copies of the documents and records related to the department's Facebook page. The city has approximately 53,000 records responsive to that request, and as a result, we received the attached invoice in response to your request. If you want to narrow the scope of your request for documents, the city will work with you to provide you with a response and new estimate if a deposit is necessary. With respect to the 6 questions raised in your attached request and stated again below," and now I'd like to point out real quick, even Mr. Mandel noted that 1 of my 6 were actually asking for records. And I admit that I phrased them in the forms of questions, but I was not asking questions for them to answer. I was asking questions to elucidate what records I want. City has a habit of playing semantics games. For instance, one time I filed a request asking for timesheets, and they gave me something completely different. And then I questioned the city as to them not having timesheets, and they're like, "Oh, you meant the time roster." And so if I don't use the exact semantic language that the city's using, they'll use that to not produce the records. So I formulated the records I was seeking in the form of questions. And if there was any ambiguity or misunderstanding on their part, the city had a duty and obligation to reach out to me for clarification, which they did not do.
Can you finish reading that paragraph that you recited just for completion of the record?
With respect to the 6 questions raised in your attached request and stated again below that paragraph, Mr. Mandel?
Yes.
Please understand that those questions do not ask for documents, and therefore Chapter 119 Florida statutes does not apply to your inquiries. Florida law is clear that Chapter 119 does not require the city to answer questions regarding city's records. See AGO 9238. To this end, if there are specific records you would like to request relating to the Facebook page, you may make such requests, and the city will make all non-exempt responsive records available for your review. However, the city need not and will not produce an employee to answer your questions regarding any such documents. I agree with the legal basis there. I just disagree that that's a proper interpretation of my request. And we also, you can see in my earlier email, I made very clear that I was not seeking 53,000 records. He, again, here says 53,000 records. Now when we go to my next email, "Dear Mr. Zeskind, thank you for the response regardless as 3 months after I filed my request. Again, there are not 53,000 responsive documents because I did not ask for any such record. If there are no records to be requested in my questions, that is fine. I'm going to repeat that. If there are no records to be requested in my questions, I'm clarifying here that my questions aren't asking questions, but they're to seek records."
Right, but here you clarify that you're looking for a policy of regards deleting comments, blocking people from commenting.
And so it says,
yeah.
It would be expected that there would be at least records for the policy for deleting comments and blocking people from commenting on the official Facebook pages, or who has such authority to make determinations of a record log or deletion. This is not me narrowing my request. This is me stating, like, what I consider to be absurdity that they did not have records or they were playing this game with. I felt like they were playing games with me, Your Honor.
Okay.
Now we go. The next email is just me. I didn't say everything I wanted to say in the first email, and I cite AGO opinions and case law. Then you can see Mr. Zeskine replies back again, "Good morning, Dr. McDonough. It seems as though you misunderstood my email below. I did not state the city is not maintaining the records from the department's Facebook page. To the contrary, you've been advised now on multiple occasions that, in fact, the city has over 53,000 records related to the Facebook page." Mr. Zeskine here is clearly not paying attention to my emails and my clarification of my request and continues to mischaracterize my request. And then I sent him another email, and as you can see, again, I did not ask for, nor do I want a copy of the 53,000 Facebook post. So, I mean, there was quite a bit of back and forth between me and Mr. Zeskine, where I was trying to explain that my questions were the records I was seeking, and the city refused to act on that, with the exception of later coming and providing the deletion, or stating there was no deletion logs and stating there was no policy allowing for deletion.
Okay, so the one thing that you never, the one answer that you never got was the name of the administrator.
That's one thing I know for sure has to exist that has not been produced. I assume and speculate, again, that there would be emails or memorandums or some other records related to the page for the creation of the page, who was going to control the page. And again, it's speculation, but it's being a government employee, it's hard to imagine that a government agent would just go and spend money to create a page without there being some foundation for it.
Right. Well, that would still be speculative, but you are saying that, but at the very minimum, they could have provided the name of the administrator.
They could have provided the name of the administrator, and if there's no emails or memorandum related to the creation of the page or who's going to have control of the page, they can easily state on the record that no such records exist, but they've failed to do that to date, Your Honor. And this request was filed in 2015, so I've been waiting on the answer for nearly 8 years now. And again, the city has blocked any real access to the records because the city's deleting my comments, which I'll show you in a minute. They actually didn't delete my comments, they hid my comments. But either way, that's censorship, which is unlawful. The third lawsuit in the United States of America for suing a government or police department for censorship on Facebook was filed by me against the Miami-Dade Police Department.
Your Honor, I'm going to object and move to strike. This is completely way afield from where we're talking about First Amendment lawsuit. This is not a First Amendment lawsuit. It is not about his history and all that stuff. That's completely irrelevant. I'll move to strike it. We're just talking about these requests.
All right. So, Mr. McDonough, let's just stay. Let's just stay within the confines.
It's not a First Amendment lawsuit, Your Honor, but the reason I mentioned the First Amendment in my other lawsuit is I had intended to sue City of Homestead or the police department for the censorship had they provided me the records. They have never provided me the records, and the statute of limitations has expired. So any real access to public records for the reasons for which I sought the public records was denied by the city here. And I think that's a very important point, Your Honor. And let me stop sharing this. And I would like to bring up exhibit exhibit 27. This is the deposition transcript of Zach Good, the PIO for the city of Homestead. This deposition was taken in this case.
Your Honor, I'm going to object to this. He's trying to use a deposition of a city employee. He did not designate any, did not list him even as a witness, didn't put him under a trial subpoena, didn't designate the portions that he wants to read into the record. I would move to strike this, and also note my objection as well that he can't use this for.
All right, and this person's now been dropped from the lawsuit?
This person was never a party. Okay. This is an employee of the city of Homestead, and actually, it was an employee of the city of Homestead that was taken in October of, I think, 2017, And it has nothing to do with, again, the issues that we are talking about today, and specifically the responses to requests 4 through 6. And again, did not designate the transcript, cannot use this, hasn't set a basis to use a transcript of a city employee, and it's improper. Should not be allowed to use it, Your Honor.
Mr. Mandel is right on that point. So I'm sorry, Mr. McDonough, but
I noticed this is an exhibit. And it's a statement of a party. I was just trying to show Mr. Good's statement.
yes, but it's not proper.
Okay. Okay, so I'll just say that, to date, the city has not attempted to interpret request 5 as I filed it, or clarify, or attempted in any way to cooperate with me to understand what records I was seeking. That to be canceled. So I'd like to move on and discuss, because I think it's very important for the record, and I will like to bring in exhibits, that the city has animosity towards me, which I believe explains a lot of why I have problems getting my public records request.
I would object again, Your Honor, not relevant at all to whether or not the delay was reasonable. You have to understand, Mr. McDonough, Dr. McDonough has sued the city at least 10 different times. There is ongoing litigation and state court and federal court. We can't let this turn into that. This is the limited issues as framed by Judge Ruiz Cohen really is whether or not the production of 4 through 6 were reasonable or unreasonable delays. And for Dr. McDonough to go into this whole history again about animosity and all that has
All right,
no bearing on
Mr.
public
McDonough,
records.
when you get ready to provide your closing argument, I will allow you to make an argument of any as far as unreasonableness, if you believe that the city has dealt with you in an unfair manner or with bias against you, certainly you can, I will allow you to use that argument, but I cannot let inadmissible evidence to come into the hearing. But I will allow you to make, whatever argument you wish to make when the time comes.
Okay. Let's see what else I have. Okay, well, next then, skipping ahead, I would like to show my exhibit 20. And this is a motion to compel filed by the city. Defendant City of Homestead's motion to compel better discovery responses.
Your Honor, I would object. First of all, Your Honor could take again notice of the.
All right, that's fine. It's something that of course the court takes judicial notice of everything that's been filed. But if he wants to point something out, I'll allow him to use it as a demonstrative. Go ahead.
It goes to the issue that we just talked about. Again, he's going to go into this whole animosity argument.
Right, but this is
not
different.
Really evidence, but
because this is something that that is part of the court file that the court can take judicial notice of. Go ahead.
But it's relevant as well.
Your Honor, this is relevant to the issue of costs. I'm seeking my cost of enforcement, and the City of Homestead is claiming that I filed or maintained this lawsuit for an improper purpose and asking that I pay their attorney fees, which as of August of last year was over $215,000 in this case. So I think it's very important and very relevant to the issues of the case here.
I would, again, Your Honor, he's making argument because again, we're in the evidence portion. We move to strike as speculation and lack of foundation.
All right. I'm going to allow him to show me whatever it is that you want to show me about that document. Certainly, the document speaks for itself, and Mr. McDonough, you're free to make whatever argument you wish when the time comes, but go ahead and point out what it is that you want the court to see with regards to this document.
Yes, ma'am, Your Honor. Let me just scroll down to where it's at. Here it says, with respect to relevance of McDonough's online posts, the city is aware of at least one instance where McDonough has stated that he intends to someday write a book on how to harass government entities with public records requests and prevail in court on the subsequent lawsuits. The city is entitled to know whether McDonough has made any other similar or related representations as they're wholly relevant to the city's defense that McDonough's complaint was filed for an improper purpose, and that his barrage of public records requests, as well as the subject complaint, represent a complete abuse of Florida's public records law and are nothing more than an improper attempt to harass the city. Then he goes on to cite Florida Statute 119.12, which says that if I file for an improper purpose, that I have to, not only do I not get my costs, but I have to pay their fees and costs.
Okay.
After that, I then had emailed Mr. Zeskine asking for a copy of any of the evidence that he had that I had ever made such a statement.
In other words, that you were planning to write a book, or that you were...
That I had stated that I was going to teach people how to harass government entities. That's a pretty bold statement to be making, in my opinion, Your Honor. This is my Exhibit 21. I would move to enter into evidence. This is a screenshot sent to me by Mr. Zeskine, the city's attorney, when I questioned the evidence of his statement. You can see
again, I would object to this exhibit being into evidence as relevance. And
all right. Well, I think Mr. McDonough, I'm going to wait and rule on this after Mr. McDonough has had an opportunity to link it up. First, show me what it is that you want. I think what you're trying to do is show me where the source of that request for admissions came from.
Yes, ma'am, Your Honor. So you see, I say it's only beginning. Mr. Jody Thomas says, I hope you help other people when this is over. And then I respond, I say, that's the plan. Want to write a book on how to do this and when. So I admit I wrote that statement. I never said anything about teaching people how to harass government entities. I never said anything about harassing anybody. The law is very clear that even if I filed 300
so write a book on how to do this, and when means on how to obtain information through public means.
Yes, ma'am, Your Honor.
Through public records requests. Okay.
I didn't want to change anything because this is what was sent to me by Mr. Zeskine. To give you a background, after the July 31st, 2017 immediate hearing in this case, when the judge, Jennifer Bailey, ordered the city to provide records from requests 1, 2, and 3, when I left the hearing, I went and wrote, "We won!" Exclamation point, exclamation point. Another one of my friends said, "Great, I hope this is all over for you and your family now." And that's when I said it is only beginning.
Okay.
So you didn't see that part beforehand. I didn't want to add it because it wasn't
I see. You just wanted to give me the context. Okay, very good. All right, so you're saying that the part about the writing a book that was in the request for admission must have come from you're trying to suggest to the court that this must be the source, because you've never written a book or told anybody that you're planning to write a book other than in this posting.
After Mr. Zeskine filed the motion to compel, I emailed Mr. Zeskine demanding all evidence he had that I had ever made such a statement. This is the only thing that Mr. Zeskine responded back with.
Okay.
So this is the evidence that Mr. Zeskine is saying supports his claim that he's aware that I made a statement that I was going to teach people how to harass government entities with public records requests. And this is not testimony, but I would also note that The public records law and case law is very clear. Even if the city hates me or thinks I'm a malcontent, I have a right to pursue public records requests. And even if I filed 100 or 200 records requests, that does not meet the definition of harassment. I have an absolute constitutional right to file public records requests. And
Your Honor, I'm sorry, Mr. McDonough. Your Honor, I just, whenever we have an opportunity, we've been going for 2 hours, I would request a 5-minute comfort break.
Okay, all right. We can. I was actually going to suggest that we take a break, and let's see. It's almost 12 noon now. I mean, we do have a. I did set aside plenty of time. You have the whole afternoon. Is it okay, everybody, if we have like a half-hour lunch break?
That's fine with me, Your Honor. Since we're not going to discuss anything about declaratory and injunctive relief, I've finished my case. That was the last exhibit. If I could just move to enter that last exhibit.
Well, I'm going to, that's going to be part of your argument as to where, your contention that the request or was it a request for production or was it a request for admission that you were sent by Weiss Rhoda? A request for production. Okay. So yes, basically what you've demonstrated to the court is that book comes from that you haven't written a book and that that the only place that that could have come from, and that Mr. Zuskine himself advised you that that's where he got that notion.
And importantly, I never stated ever that I was planning to teach people how to harass anything.
Okay, yeah, understood. All right, and that will be certainly part of your argument when the time comes. Mm-hmm. So let's go ahead and take a half hour. If that's good for everybody.
Okay. Hi, Your Honor.
Hello, Dr. McDonough. Let's wait for everyone to get back.
Hi, Your Honor.
Okay. All right, and so before I turn it over to Mr. Mandel, in case he has evidence to present, I just wanted to ask Mr. McDonough, do you have other documents or anything else that you'd like for the court to take judicial notice of before I turn it over?
I think everything else I'll save for my closing arguments, Your Honor.
Okay, perfect. All right, so Mr. Mandel, now I'm going to switch it over to you. I think you mentioned that you wanted to present some sworn testimony.
Yeah, I do. I just want to, Your Honor, may allow me to indulge in some brief cross of Dr. McDonough. You hear me?
Yes.
Hello?
Yes.
Okay. Okay. So whenever the court is ready, I'm ready.
Go ahead.
Okay. Dr. McDonough, I'm going to share my screen and I'm going to show you what has been marked as Defendant's Exhibit E. 1 second.
Is this one of the stipulated exhibits?
No, it's not. You didn't stipulate this one. I just want to kind of go over it with you real quick. And it's an email from Elizabeth Sewell to phd2b05@gmail.com on June 15, 2015 at 6:52 p.m. Dr. McDonough, your email address is phd2b05@gmail.com, correct?
Yes, sir.
Okay. And you received this email from Ms. Sewell on June 15, 2015, correct?
I don't recall receiving it, but I doubt that you would file a false document, Matt, so I'll take your word for it.
You have no recollection of this document, Dr. McDonough?
I don't remember. I know you showed it earlier. I don't remember receiving it. I got thousands of emails.
Okay.
I'm not contesting its authenticity. I'm just saying I don't personally remember receiving it.
Yeah, okay. So you're not doubting the authenticity? Would you stipulate for the record that that we can get this document into evidence since you don't dispute the authenticity?
Do you have a witness to call for it that could?
I'm asking you the question, sir. Since you don't have any issue with the authenticity, would you stipulate to this document going into evidence?
I don't see the. I'm not sure I can stipulate to that, Mr. Mandel. If the judge wants to enter it, then the judge will enter it.
Let me ask you, you did testify earlier that the city did respond. Let's look at the first two paragraphs. In regards to your public records request for the destruction logs, for the deletion of your comments on the Facebook pages of the Homestead Police Department, the city, and the mayor, there are no destruction logs because no comments have been deleted from the city, police, or mayor's Facebook pages. You did testify earlier that the city did respond to that specific request, that they didn't have those documents, correct? You did say that.
I was basing on you showing this email earlier.
You testified to that during your case in chief. Isn't that true, Dr. McDonough?
Yes, sir, Your Honor. I testified that other than the destruction logs and the policy for allowing a deletion, that otherwise no responsive records have been produced or no records have been claimed to not exist. I did testify to that, correct.
Again, you specifically testified that it relates to the destruction logs that the city said we don't have them, correct? You did testify to that.
I testified to that based on reading your email. Yes, sir.
Right? And you also likewise testified in regards to the second paragraph in regards to your request for the policy allowing for the deletion of critical comments. The city does not have a document that is responsive to that request. So you did ask for the policy allowing for the deletion of the critical comments, correct? You did ask
Correct.
for that.
Yes, sir.
Right? And you did testify that the city said it didn't have that policy.
To that extent, yes, sir.
Okay. And you can't tell me one way or the other whether you learned of that from this email when you were receiving this email?
I don't remember receiving this email. When you showed this email earlier during your opening statement, I read it, and so I testified that with the exception to the deletion logs and the policy, that nothing had been produced to me.
Your Honor, given that
Or
he
stated that no records exist, with the exception of those two.
Your Honor, based on his testimony before and now, and also the fact he doesn't dispute the authenticity, I would like to see if we can get this into evidence. I don't understand any basis for his objection to it, but I would like to move this into evidence.
Just all right. I'm going to enter it into evidence. Not, to be used for the truth of the matter asserted, but just as a responsive document to his public request.
And he received this document. Okay. Okay. I don't have any more questions for Dr. McDonough. I'd like to just call briefly a witness that we have, Captain Raymond DeJean from the Homestead Police Department.
All right. I'm not sure if Alba is back from lunch. Could you remove the screen share? I'll just swear him in myself.
Oh, sorry, Your Honor.
Well, quick question. Was Mr. DeJean or Captain DeJean put on your witness list? I don't recall.
I listed a corporate representative for the city of Homestead.
I'm sorry, I couldn't hear you, Matt.
Representative. We listed a corporate representative. He's our corporate representative from the city of Homestead. He's been sitting with us the entire trial. He's been listed. He's been designated.
But was he listed on the witness list?
I said we listed a corporate rep, and he is our corporate rep.
Okay, I don't remember that, but okay.
Okay.
To the extent that he's not on the witness list, I object because the order was very clear that we had to list all witnesses, and city has made issue in the past with me not listing all witnesses. So to the extent that he's not on the witness list, I object.
Okay, and Mr. Mann, you're saying you did have you did include a corporate rep. I guess that sometimes they don't put the name because the corporate reps sometimes their identity changes. I know that I've had that with other business entities.
Yes.
They'll put corporate rep instead of a name only because by the time the case actually goes to trial, there could be, I guess, a different.
That's exactly right. That's exactly right. This case has been pending for quite some time. So he's our corporate rep.
Okay, very good. All right. Okay, so let's get Alba now that you're back with us. Hi, Alba. If you could swear in Captain R. Dijon from the Homestead Police Department, who is in his capacity as corporate rep.
Sorry. Yes, Judge, I'm on. Can you please raise your right hand, sir? Do you swear or affirm that the evidence you're about to give would be true, the whole truth and nothing but the truth?
Yes.
Thank you.
Good afternoon, Captain John. Can you state your full name for the record, please?
It's Captain Raymond David
Your
Dijon.
current occupation, sir?
I'm a with the Homestead
How long
Police
have you been,
Department.
sir?
As a captain, I've been in that position 7 years.
And how long have you been with the Homestead Police Department overall?
Just over 17 years.
And sir, can you briefly describe your job duties at the Homestead Police Department?
I'm assigned to the command staff. The command staff is basically the chief's executive staff. I oversee the administrative division.
When we say you oversee the administrative division, can you briefly describe that?
Yeah, my duties under the administrative division is I'm responsible for the report writing quality control section. I'm in charge of the IT section, the body camera unit, the crisis negotiations team, the CIT or crisis intervention training. So I'm aware of many different hats under that position.
You said earlier that you're part of the command staff. How many members are on the command staff?
You got the chief, the colonel, and 4 or 5 other captains.
Are those the seven highest ranked positions in the police department?
Yes.
And what are you mentioned body cam. What are your specific duties with respect to body cams, Captain Dijon?
Well, I oversee it. I was involved in the development of the body camera unit, developing the formation of the body camera unit itself, seeking out the funding of the body cameras, the implementation, and just getting it started.
And what are
Excuse me, I'd like to object on relevance.
All right, Mr. Mandel, is this to support the some of the
videos
the
issue?
video?
You're
Okay, all right.
I'm gonna be very brief, but I'll tie.
There's no body camera video here.
I thought I heard some evidence that there was a request made for body cam or video, or maybe it was for dashboard cam.
That's correct.
There was dash cam related to request 4, and there was cell phone footage related to request 5. There was no body camera footage.
If I can have some latitude, Your Honor, I'll definitely show the relevance.
All right.
It's how the city produces videos when they get requests.
Okay, for that purpose, then go ahead.
Yes, Your Honor. So, briefly, what are body cams? Just very briefly.
Body cameras are a recording audio and video recording device that's worn upon the officer to record our interactions with citizens.
Okay. How long has the city?
This is completely irrelevant to the case at hand.
I think Mr. Mandel is going to try to link it up, and I will then make my decision as to relevance.
Okay.
How long has the city been utilizing body cams, Captain Dijon?
Since January 2021.
Okay. And prior to using body cams, did the city use other mediums to record interactions with the public?
Yes, very limited, but they had dash cams. The traffic unit did.
Okay. And dash cams aren't used anymore?
No.
And is that because the city now utilizes body cams?
Well, before we even went to body cameras, they began getting phased out. They were older quality cameras, and they were phased out, and nothing else was purchased. So we eventually went with the body cameras.
Okay. And are you presently in charge of when the city gets a public records request right now for body cam footage? Are you in charge of that?
I'm not directly in charge of it, but I do oversee the unit as far as them processing of the body cameras when they get a request when in their processing that they do.
And does the city produce body cam footage in response to public records requests?
Yes.
And does the city currently blur or redact the identity of any officers in body camera footage?
Yes.
Who do they redact or blur?
Undercover officers.
Why is that?
Obviously, to protect their identity, for their own safety, to you know, help protect the ongoing or future investigations, which they may be involved in.
Does the city redact or blur out the identity of any officers that are either uniformed or non-undercover?
No.
And was there a time when the city redacted more than just the identity of undercover officers?
Yes.
Produced dash cam or body cam video?
Yes.
Okay. And what did the city redact? What did the city do?
When we had dash cameras,
Yes.
we would redact all officers that showed up on the dash cam video.
Okay. And why did the city redact the identity of all officers on the dash cam videos?
Well, the reasoning was it was our understanding of the law at the time as to the advice that we got from the city attorney's office during the course of these public records requests.
And are you aware of the practice of other law enforcement agencies with respect to production of dash cam videos?
The back during several years back, it seemed to be the standard that they would also redact officers' faces, and that's changed over time.
Excuse me, do you have any evidence of this or personal knowledge of other police departments? I'm wondering what the foundation of this is.
Your Honor, he can cross-examine if I can just finish my examination.
Go ahead. You'll have an opportunity to cross-examine on those questions, Dr. McDonough.
Thank you, Your Honor.
And again, at some point, Dijon, the practice of redacting all officers' identities with this from the city of Homestead, it changed. Is that correct?
That is correct.
Okay. And you stated that the reason why that policy changed.
Well, as we were developing the body camera unit, we were taking a look at and seeking advice from the city attorneys on how we should be doing these redactions, and we just decided at that point, based upon the advice, that we would, because it was so commonplace now when you see body camera footage, you do see the officers' faces, so we would go ahead and leave their faces unredacted as a standard of practice that was throughout the state, and based upon the advice of the city attorneys.
Okay. No further questions. Thank you, Captain Dijon.
Okay, and now, Mr. McDonough, you can, Dr. McDonough, you can go ahead and cross.
Thank you, Your Honor. Captain Dijon, were you in charge of body cameras or dash cameras in 2014, 2015, or 2016?
No.
And you admit that the city didn't get body cameras until January 2021. Is that correct?
That is correct.
So that's roughly from 2016, when my last request seeking cell phone footage, to the implementation of body cameras. From 16 to 21 is 5 years. Would you agree with that?
Yes.
And before 2021, did you have any interaction with what was being done with body cameras or dash cameras or any other footage that the Homestead Police Department would have?
Not with dash cameras, just originally in 2016, I was attempting to implement body cameras. We couldn't get the funding back then, so it came around again, and in 2021, we were able to go live, purchase body cameras, and go live with them. So I've been involved with body cameras trying to get it implemented since about 2016.
It's about 2016. And when you started trying to get body cameras implemented in 2016, were you doing anything to educate yourself or learn about redacting police officers from video footage?
Not necessarily, I mean, obviously that conversation came up or as you're looking at things, but my concentration back then was actually trying to get the cameras purchased.
Do you know roughly when that conversation came up? Not a specific date, but could you guess a year or a month maybe?
Yeah, it was 2016 when I was a captain. That was one of the first things that I began working on. 2016, 2017. I think it was around October 2016 that we were trying to make it happen.
But when you were trying to make it happen, were you discussing redaction of video, police officers at that point?
No.
No. Okay. And you stated that currently y'all redact any images of undercover officers, but you
That
don't
is
redact images currently of uniformed officers.
correct.
Okay. Do you know why the city stopped redacting non-undercover officers?
It was based upon just with discussions with the city attorney's office. As moving forward with the body camera unit, as we were, trying to get it kicked off, and based upon what you're seeing, everything from different things when people do public records requests and ends up in the news or something like that. A lot of times previously in years past, going back to 2014, 2015, you would often see their faces redacted, uniform officers. As the years had gone by and body cameras became more prevalent, we actually started to see, more visualization of actually the officer's face unredacted.
So is your testimony here today that in 2014 and 2015, when we were seeing dash cams or body cameras on the nightly news, that the police officers' images were redacted?
No, I'm not saying that it was always. I'm saying there was a lot of times there was, sometimes there wasn't, and it depended upon maybe the state that it was coming from or the department that it was coming from. But again, my understanding of the way it was back then was it was based upon the advice of the city attorneys and the way it was in the state, that a lot of times it was being redacted.
Well, would you agree that the majority of the times in the 2014, 15, 16 time frame, that when we saw body cameras or dash cameras on the nightly news, that the police officers' images were not redacted?
I wouldn't have to agree that it was the majority. I would say that I've seen numerous body camera footages from both sides where they're either unredacted or redacted from different agencies.
And I don't want to have any problems with attorney-client privilege. So the next couple questions I'm going to ask you, if you learn this solely because of discussions with the attorneys, then state attorney-client privilege, and you don't have to answer. But other than through the attorneys, have you had any discussions with anybody about redacting non-undercover officers on video?
No, and specifically, you talking about that time period back then?
Yes, sir. In the 2014 to 2016 is where I'm concerned at, because those were when the requests were filed.
Okay. It seems like back then, when it was either right before I became a captain or right after I became a captain, we had gone to a public records training, and back then we were being instructed by training, and also it goes with what we knew from what the city attorneys were saying, was that we could redact officers' faces.
Now, when the discussions came to where we're going to no longer redact officers' faces, was there any discussion about, even though y'all weren't going to do that anymore, that it was lawful to do such?
No, it was never saying that it was lawful to do such. At that point, we were just, again, I was reaching out to the city attorneys, trying to go over, how we were going to proceed with the implementation of the body cameras, and discussing many things, one of which is, doing redactions. And it was just clearly stated that we're going to redact undercover officers' faces. And again, it was basically a trend that we were seeing as we were seeing more body cameras being implemented, especially with, that I saw within Dade County, that patrol officers' faces were unredacted. So that's when we, said, okay, this is what we're doing. Again, we didn't have any cameras since they got rid of the dash cameras at some point, which I was not involved in. But going forward with the body cameras, we were going to go ahead, and this is the way we're going to do it. We're obviously going to, protect the identity of the undercover officers. For that for that time period. But as far as patrol officers, because it's so commonplace at this point, we're not going to redact their faces.
Okay, and I understand redacting anything, not just an image, anything that reveals the identity of an undercover officer. That completely makes sense. The Florida statute is very absolutely crystal clear on that point. My next question is, if there were discussions that redacting uniformed officers was lawful, so the city's allowed to do those redactions, but the city did not do those redactions, does the police department feel that not redacting the images of uniformed officers is a safety hazard for the police officers?
I mean, sure, there's concerns for the officers anytime their faces go on there, but it is such commonplace. They're the ones doing the traffic stop or the encounter or whatever it may be, and they're not working in an undercover capacity. So again, this is the way the law is as we understand it now, based upon the advice of the attorneys. So that's why we made the decision that we're not going to redact their faces.
Let me try to ask this a different way. If the law would allow for redaction of uniformed officers, not undercover officers, is it fair to say if the city, a Homestead or the Homestead Police Department felt that not redacting the police officers' images would create a safety, that the redactions would be done?
Can you
Let me
rephrase?
rephrase. I didn't come out as clear as I would like. Let me think of how to say this. Is it fair to say that if Homestead Police Department felt that not redacting an image of a uniformed police officer negatively impacted their safety? So if the Homestead Police Department felt that not redacting the image threatens the officer's safety, the Homestead Police Department would redact the image. Is that correct? Is that fair to say?
And let me just clarify this, because you originally said if it was provided for in the law to do so.
If the law allows you to redact and unredacting creates an officer safety issue, I would assume the Homestead Police Department would redact it then for officer safety, correct?
I would assume we'd be approved for something like that if it was within the law.
Okay, so even though the city's position is that it's lawful to redact uniformed officers, the Homestead Police Department doesn't redact uniform officers, and that is evidence that the Homestead Police Department is not concerned for the safety of the officers.
Objection, Your Honor, mischaracterizes what he said and also vague.
I'll allow it.
Okay, can you rephrase that again? Because we're going back and forth.
Yeah, so if the Homestead Police Department could lawfully redact something, and not redacting it would create an officer safety issue, the Homestead Police Department will redact it because we want our police officers to be safe.
Yes, if we're allowed within the law, we would redact it.
Well, the city is arguing now that they're allowed to redact. And you argue that you're allowed to redact. Y'all just say that y'all no longer redact because of what you see happen on the nightly news.
Objection, mischaracterizes what he said. Mischaracterization of testimony. It's not what he said.
All right, I'm not understanding what the question is. You're asked what is it that you Okay, so this witness, I don't think it's appropriate for him to be testifying on the law and statutory construction.
No,
however, if your question is to how
my question was to elucidate the fact that the Homestead Police Department doesn't consider not redacting police officers' images to be an officer safety issue. Because another arguments that Mr. Mandel is going to make or has made is that they're allowed to redact this, and because of officer safety, they're allowed to redact photographs. So because of officer safety, that also applies to video.
all right, again, that goes into argument issues of the purpose of testimony is not really to get into these areas of argument, but just to sort out the facts.
I understand. So just real quick to make sure that this is clear for the record. Captain DeJean, if the city felt, or the police department felt, that not redacting the video was an officer safety issue, the video would be redacted. Is that correct? Was that your testimony?
You're comparing apples to oranges here. We're talking 2021, and this whole basis for this is 2015, 14, 16, whatever it may have been. So back then, our understanding of the law, based upon the city attorney's advice, was that we would redact the images. Now, going forward to 2021, when we implemented the body camera unit and having discussions with that, it was the advice of the city attorneys that we don't redact their faces because this is what the law states. Okay, so that's our understanding of it. But as far as, obviously the protecting the identity of officers is always a concern of ours. Okay, we not because people don't have a right to it because of its public information, but if there's some sort of concern for their safety, yes, we would want to do everything we can to protect the officer. But because if the law states that we don't redact their faces, and again, this is based upon the city attorney's advice, if we don't redact their faces, then we don't redact their faces. And,
Understand. One last question. Does the Homestead Police Department on its own Facebook page ever post photographs of Homestead police officers?
yes.
So when the Homestead Police Department posts photos of their own officers publicly on their own Facebook page, it's not considered to be an officer safety issue?
Again, right now, if you're talking, we don't redact officers' faces. All right, we don't do it. Whether me personally feels that it could be an officer safety issue or not, but if we don't redact it and we put it on the Facebook page, it's the same thing. Okay, it's not.
I'm sorry. Go ahead. I'm sorry. Continue.
It's not that there's we're doing what's provided for by the law as far as with the body cameras and the redaction or non-redaction of officers on the body cameras. If they put them on the Facebook page and it's a uniformed officer and let me make the distinction between a plainclothes officer and an undercover officer.
Absolutely.
Plainclothes officer could be a general investigations unit detective. Okay. An undercover officer is usually somebody working narcotics or gangs or something like that is constantly doing surveillance. So even though they're not maybe doing the undercover deals or undercover buys, if they're on surveillance, they're technically still undercover because they shouldn't be seen. So with that being said, if they're on the Facebook page, yeah, me personally, as if I was an undercover officer, I would not want to be on the Facebook page.
That's very understandable.
Right. So, I mean, obviously we are concerned, for officer safety but it also is up to that officer as far as a Facebook page goes. Hey, I don't want to be on that. And I know that's occurred before.
But back in the 2014, 2015, 2016 time range, the Homestead Police Department posted unredacted photographs of its police officers on its Facebook page. Is that correct?
I don't know because I didn't follow it.
Okay. I have no further questions. Thank you for your time, sir.
Okay.
Okay, any redirect?
No, Your Honor.
Okay. All right, any other witnesses that you wish to call, Mr. Mandel?
No, Your Honor.
Okay. All right, and would you like to then go ahead and proceed to argument?
The city.
Yes? I'm sorry.
Yes, Your Honor.
Okay, all right. So at this time,
Excuse me,
yes.
Honor. Am I excused or?
Yes. Thank you so much, Captain DeJohn. You are excused, and you may leave this virtual courtroom.
Okay.
Thank you. Okay, so at this time, the evidentiary portion of the trial has concluded, and we can go right into.
Your Honor,
closing.
before we go there,
So-
can Mr. Conductor James McDonough give me all his exhibit as he introduced it so I can have an accurate record? Can he just tell me the numbers? Or I can go over them and you tell me yea or nay, sir?
I'm sorry, I didn't write them all down.
I have them. Could you tell me yes or no? I have one, two, and three, six, pardon, 8, 9, 10, 11, 12, 13, 14, 16. That's it.
I, if you would like, when the hearing's over, I'm happy to go through it, and I'll send you exactly which exhibits that I listed. But off
Okay.
the top of my head, I can't write. I
Okay.
have to look at my notes.
Okay, that's fair. Thank you. Thank you, Judge.
Ma'am, would you like me to do that?
Yeah, sure.
Is there an
You,
email or something that I could send that to you?
yes. I'll put it in the chat.
You put in the.
Okay. I'll put
Okay.
my email.
All right.
Thank
Thank you
you.
so much.
Welcome.
As soon as the
Thank.
trial's over, I'll get that right to you.
Okay. Thank you, Judge.
Okay, let's go ahead and proceed then to closing arguments.
Okay. So I assume I get to go first.
Yes, go ahead.
Thank you, Your Honor. First point is the city improperly redacted video footage in requests 4 and 6. The general purpose of Florida Statute 119, quote, is to open public records to allow Florida citizens to discover the actions of their government, end quote. Christie v. Palm Beach County Sheriff's Office, 698 Southern 2nd, 1365 at 1366 Florida 4th DCA, 1997. Quote, because Florida's public policy favors disclosure, the Public Records Act is construed liberally in favor of openness, and exemptions from disclosure are construed narrowly and limited to their designated purpose, end quote. City of Miami Beach versus Miami New Times, LLC, 314 Southern 3rd, 562 at 565 Florida 3rd DCA, 2020. The right to access public documents is virtually unfettered, save only for the statutory exemptions designed to achieve a balance between an informed public and the ability of the government to maintain secrecy in the public interest, end quote. Times Publishing Company versus City of St. Petersburg, 558 Southern 2nd, 487 at 492, Florida 2nd DCA, 1990. An agency claiming an exemption from disclosure bears the burden of proving the right to an exemption. See Barfield v. School Board of Manatee County, 135 Southern 3rd, 560 at 562 Florida 2nd DCA, 2014. Further, quote, when in doubt, the court should find in favor of disclosure rather than secrecy, end quote. Tribune Company versus Public Records, 493 Southern 2nd, 480 at 483 Florida 2nd DCA, 1986. Your Honor, here in request 4 and 6, defendant City of Homestead redacted images from video footage of uniformed police officers acting in public. After plaintiff filed the action and after City lost its argument on the October 18, 2008 hearing on its motion to dismiss and the summary judgment in March of 2021, or after the motion to dismiss, City produced the unredacted versions of the requested videos on December 20th, 2018. This was more than 4 years after the filing of request 4 and more than 2 years after the filing of request 5. City has cited Florida Statute 119.071 parentheses 4 parentheses D 2.A. to support redaction of the video. However, Florida Statute 119.071 4D only exempts photographs. Florida Statute 119.071 4D 2A. Would you like me to show the statute, Your Honor?
No, you can just
Okay.
just read it.
It
Read it
states
into
in
the
part,
record.
quote, the home addresses, telephone numbers, dates of birth, and photographs of active or former sworn law enforcement personnel are exempt from Section 119.07 parentheses 1 and Section 24 parentheses A, Article 1 of the state constitution. The legislator and this court have recognized the difference between photographs and videos within the same chapter. For instance, or example, Florida Statute 119.071 parentheses 2 parentheses H 1 dot C dot states in part a photograph, videotape, or image. And I also showed the trial exhibit, my exhibit 10, which was the transcript from the October 18th, 2018 hearing where Judge Rebull denied their motion to dismiss on these same arguments. And at summary judgment, in March of 2021, the same arguments were rejected once again. The city ignores this differentiation between video and photographs clearly expressed in the statute and cites Ramses, Inc. versus Demings, 29 Southern 3rd, 418, Florida 5th DCA at 2010, for the proposition that under Florida Statute 119071, parentheses 4, parentheses D, quote, photographs, end quote, include video footage. Ramses again involved video of undercover officers and provided that release of records during discovery does not invalidate the exemption under the statute for information revealing the identity of an undercover officer. The holding in Ramses was based solely on 119071 4C and was not based on 119071 4D, nor does Ramsey claims what the city has alleged it does. The city's unlawful redactions created excessive charges, unduly delayed production, and denied access to all responsive and non-exempt public records. Further, production of the unredacted videos after the fact is done here does not moot the issues of the lawfulness of the response or moot the issues of my entitlement to cost. Therefore, city failed to meet its burden to show that it was entitled to the exemption, and as such, the redactions applied to the videos in requests 4 and 6 were unlawful. The city interpreted request 5 in an overbroad manner and inflated the hours. Florida Statute 11907, parentheses 4, parentheses D, authorized the imposition of special service charge when the nature or volume of public records to be inspected is such as to require extensive use of information technology resources or extensive clerical or supervisory assistance or both. However, the statute mandates that the special service charge must be reasonable. In Cardin v. Chief of Police, 696 Southern 2nd, 772 at 773 Florida 2nd DCA 1996, the court reviewed a challenge to a service charge that exceeded $4,000 for staff time involved in responding to a public records request, and said that an excessive charge could well serve to inhibit the pursuit of rights conferred by the Public Records Act, end quote. Accordingly, the court remanded the case in Cardin and required the agency to, quote, explain in more detail the reason for the magnitude of the assessment, end quote. See also Board of Trustees, Jacksonville Police and Fire Pension Fund versus Lee, 189 Southern 3rd, 120 at 129 Florida 2016, noting that, quote, excessive unwarranted special service charges deter individuals seeking public records from gaining access to the records of which they are entitled. A records custodian must furnish copies of records when the person requesting them identifies a portion of the record with sufficient specificity to permit the custodian to identify the record. Woodward v. State, 885 Southern 2nd, 444 at 446, Florida 4th DCA 2014. Further, if a request is insufficient to identify the record sought, the city has an affirmative duty to promptly notify the requester that more information is needed in order to produce the records. It is the responsibility of the city and not the requester to follow up on any request for public records. Salvador v. City of Stewart, number 91-812 CA, Florida 19th Circuit, 1991. For instance, the person seeking to inspect all financial records of a municipality may not be required to specify a particular book or record he or she wishes to inspect. State ex rel Davidson v. Couch, 156 Southern, 297 at 300, Florida, 1934. In Davidson, the Florida Supreme Court explained that if this were the case, quote, one person may be required to specify the book while another and more favored one, because of his pretended ignorance of the name of the record, might be permitted examination of all of them, end quote. Such a result would be inconsistent with the mandate of the Public Records Act that public records are open to all who wish to inspect them. Here, Your Honor, Request 5 was clear in asking for specific records related to the administration of Homestead Police Department's Facebook page, and to any extent it wasn't, my clarifications should have made it clear. The records sought did not include any posts, comments, or messages to Homestead Police Department's page. The request instead sought records related to the management of the page and the censorship that had occurred. At the deposition of Zach Good, the city's public information officer, Mr. Good admitted that Mr. McDonough's comments had been hidden from social media, from city social media. City interpreted Request 5 in an overbroad manner, leading to excessive special service charges of over $5,000 for records that were not even sought by me. Even after repeated clarifications, the city refused to modify its interpretation of Request 5. To date, the city has failed to produce any records that are responsive to Request 5 or to attest on the records that no such records exist, with the exception of they have admitted that they have no deletion logs and they have admitted that there's no deletion policy. Also, to any extent that city is relying on anybody responding to this request other than Elizabeth Sewell, the city's custodian, the city failed to provide the identity of the designee of the custodian of records, which is required under Florida Statute 119.07, parentheses 1, parentheses B. The city has no discretion in this respect. When the custodian of records sends a records request to someone else to work on it, they must identify that person, and that was never done here, Your Honor. Critically, city attempted to charge $5,159.55 for the production of posts and comments that had been publicly made and that did not need any review or redaction time, inflating the time and thus inflating the expense for public records reduction. This was shown when, after the July 31st, 2017 hearing, city produced the complete page histories of the city, the police department, and the mayor's page, which did not contain any exempted material. However, that still did not lead to the production of responsive records sought in Request 5. Therefore, city interpreted Request 5 overbroadly to unlawfully levy excessive charges which inhibited McDonough's access to public records. And to date, the city has refused to cooperate with me to provide the records or failed to attest that none exist except for the 2 exceptions that I've noted. The city failed to waive the first 30 minutes of time in Requests 4, 5, and 6. Florida Statute 119.07, parentheses 4, parentheses D, authorizes the imposition of a special service charge when the nature or volume to be inspected is such to require extensive use of information technology resources or extensive clerical supervisory assistance, or both. Well, again, the charge must be reasonable. See also Board of County Commissioners of Highland County versus Colby, 976 Southern 2nd, 31, Florida 2nd DCA 2008, and, which found that special service charges apply to requests for both inspection and copies of public records when extensive clerical assistance required. A determination of whether the nature or volume of public records requires such extensive assistance must be made on a case-by-case basis. The special service charge may not be routinely imposed. See Attorney General Opinion 00-11. Florida Statute 119.07, parentheses 4, parentheses D, quote, does not identify the legislator's intent as to what may constitute extensive use and provides no definition of that term, end quote. Attorney General Opinion 13-03. In light of the clear indication in the statute as to the meaning of the term extensive, the Attorney General's office has suggested that agencies implement the service charge authorization in a manner that reflects the purpose and the intent of the Public Records Act and does not constitute an unreasonable infringement on the public statutory and constitutional right of access to public records, end quote, from Attorney General Opinion 13-03. In addition, the Attorney General's office also strongly encourages agencies to adopt a public records procedure that addresses the imposition of a special service charge in the document. To address the requirement of only billing for extensive use of resources or assistance, the city has a policy of waiving the first 30 minutes of time required to produce records. Again, however, in Requests 4, 5, and 6, the city refused to waive the first 30 minutes of time, thus leading to excessive charges for the production of public records. Therefore, the city unlawfully levied excessive fees when producing public records. The city charged fees beyond its direct costs when it produced records in Request 4. Providing access to public records is a statutory duty imposed upon all records of custodian and should not be considered a profit-making or revenue-generating operation. Attorney General Opinion 85-03. Thus, public information must be open for inspection without charge unless otherwise expressly provided by law. State Ex Rel. Davis v. McMillan, 38 Southern, 666, Florida, 1905. Your Honor, Florida Statute 119.07, parentheses 4, parentheses A states that the The custodian of public records shall furnish a copy or certified copy of the record upon payment of the fee prescribed by law. If a fee is not prescribed by law, the following fees are authorized. A. 1. Up to 15 cents per one-sided copy for duplicated copies of not more than 14 inches by 8.5 inches. 2. No more than an additional 5 cents for each two-sided copy. And 3. For all other copies, the actual cost of duplication of the record. Here, and as the city's policy, they charge $5 per CD. The last time I bought a spindle of 100 CDs cost $28. So CDs are typically between 25 and 30 cents, not $5. And the charge of $5 does not reflect a cost that was actually incurred by the city. Florida Statute 119.01, parentheses 2, parentheses F, states in relevant part, an agency must provide a copy of the record in the medium requested if the agency maintains the record in that medium. In Request 5, City charged for copying fees for electronic records when the records were requested in electronic format. Electronic copies could have been produced without cost being incurred, and paper copies, as noted before, lose the metadata. One of the reasons I seek electronic copies is when they provide electronic copies, there's extra metadata in there that's not provided when paper copies are given, and that metadata itself is a public record of which I'm right to receive. Therefore, the city unlawfully levied excessive costs when producing public records. Let me get to my last section. Your Honor, I'm entitled to all my reasonable costs of enforcement, not only if I'm the prevailing party under the guidelines, but also under Florida statute. Florida Statute 119.12 states, if a civil action is filed against an agency to enforce the provisions of this chapter, the court shall assess and award the reasonable cost of enforcement, including reasonable attorney fees, against the responsible agency if the court determines that A, the agency unlawfully refused to permit a public record to be inspected or copied. Your Honor, a successful pro se litigant may recover costs under this section. See Weeks v. Golden, 764 Southern 2nd, 633, Florida 1st DCA 2000. Further, and, quote, unjustified failure to respond to a public records request until after an action has been commenced to compel compliance amounts to an unlawful refusal for purposes of 119.12, see Weeks at 633. Quote, unlawful refusal under section 119.12 includes not only affirmative refusals to produce records, but also unjustified delay in producing them, end quote. Lilker v. Suwannee Valley Transit Authority, 133, Southern 3rd, 654 at 655, Florida 1st DCA 2014. There's no additional requirement that the court find that, quote, the public agency did not act in good faith, acted in bad faith, or acted unreasonably. See Lee at 122. Unlawful conditions deter individuals seeking public records from gaining access to the records to which they're entitled. Even if not malicious or done in bad faith, the petition fund's actions were found to be unlawful, had the effect of frustrating Lee's constitutional right to access public records and required him to turn to the courts to vindicate that right, end quote. Lee 189 at 129 to 130. Quote, the fact that the requested documents were produced in the instant case after the action was commenced but prior to final adjudication of the issue by the trial court does not render the case moot or preclude consideration of entitlement to fees and costs under the statute, end quote. Major v. Orange County, 811, Southern 2nd, 857 at 860, Florida 5th DCA 2000, end 2. In Barfield v. Town of Eatonville, 675 Southern 2nd, 223 at 224, Florida 5th DCA, 1996, the court found that appellant was entitled to costs because, quote, the evidence clearly established that it was only after appellant filed a lawsuit that the documents that he had previously sought by written request to the town were finally turned over to him, end quote. In Pauls v. City of Port St. Lucie, 678 Southern 2nd, 514, Florida 4th DCA, 1996, the court noted that, quote, production of the records after the lawsuit was filed did not moot the issues raised in the complaint, end quote, and remanded the case for an evidentiary hearing on whether it was an unlawful refusal of access to public records. Thus, city's, quote, production of records on the eve of an enforcement hearing did not cure its unjustified delay, end quote. That's from Promenade de Herbeville, LLC versus Sunday, 145, Southern 3rd, 980 at 984, Florida 1st, DCA 2014. Your Honor, obviously appearing before the court pro se, I cannot claim entitlement to attorney fees, which would shift an enormous cost to homestead taxpayers innocent of misconduct by its officials. But the relatively modest expense to compensate me for my costs incurred in the many years of enforcing public Florida law should be awarded with little detriment to the public purse. With respect to the initial three requests 1, 2, and 3, City did not produce responsive records, nor did McDonough waive production of any records responsive to the initial request until after the hearing on July 31st, 2017. Admittedly, claims related to requests 1, 2, and 3 were dismissed at the August 18, 2018 hearing and or at the March 25, 2021 hearing on summary judgment, with left requests 4, 5, and 6 alive. However, it was the instant enforcement action that forced the city to finally produce the responsive records to requests 1, 2, 3, 4, and 6. Therefore, even though some claims for declaratory or injunctive relief may have been dismissed after the city was forced to, in court to comply, because the enforcement action was required to produce records of the initial and currently contested request, I'm entitled to all my costs associated with the initial filing here. Lastly, Your Honor, unredacted records responsive to requests 4 and 6 were provided years after the requests were submitted, 9 months after the complaint was admitted to include them, 4 months after the court rejected the city's argument, and 2 months after the city court rejected the city's arguments at the motion to dismiss. Records responsive to request 5 have never been produced or claimed not to exist, with the exception of the deletion logs and the policy for deletion. Therefore, there's no doubt that it was the instant enforcement action that brought forth the responsive records from the recalcitrant city, and I am entitled to all reasonable costs incurred in this enforcement action. And with that, Your Honor, I rest my case, and I would like to save some time for rebuttal if needed.
Okay. All right. Go ahead, Mr. Mandel.
Judge, I'll be brief, I promise. I'd just like to start off again, bring this back to why we're here today. And the issues were framed by Judge Ruiz-Cohen. Again, with respect to plaintiff's claims relating to request numbers 4 and 6, 4 being the dash cam video in 2014, 6 being the cell phone video in 2016. The motion is denied. The court shall have a hearing to determine whether the delay in providing the documents responsive to requests numbers 4 and 6, which were turned over after initiation of the original complaint, constitute an unlawful refusal and entitlement to award of costs. That's the first issue. So let me talk about that. The city, the evidence has shown, the city had a good faith basis to redact the videos of the identity of the officers. Based upon a reasonable construction of the statute, based upon case law, the city had maintained that position. The plaintiff in this case, while he made the request in 2014 and in 2016, didn't bring the claim challenging the redaction until March of 2018. We promptly moved to dismiss. There were several iterations of the complaint that related to 4 and 6. City maintained that the exemptions applied. And it wasn't until the hearing on October 18th where Judge Bull gave us some light into what his thinking was with respect to the exemptions and denied, or actually he technically granted it, but without prejudice as the 4 and 6, allowing him to replead. But it was in light of this ruling that the city then subsequently produced them in an unredacted form. The evidence also shows under Captain DeJean's testimony that it was the practice, it was the common practice among police departments back, especially in 14, 15, and 16, some to redact, some not to redact. And the practice evolved and changed over time. And Captain DeJean was very clear that the city's position with respect to redaction of video was based upon legal advice, based upon the city's attorneys' interpretation of the statute and legal construction, which again was that same construction that had been argued in good faith by the city attorneys at the motion to dismiss hearing, and frankly that it's an issue that hasn't really been resolved clearly by a DCA. At some point it might, but the point is that the city acted. Was it unreasonable? Whether the delay was an unlawful refusal, and it wasn't unlawful refusal. It wasn't a. It says whether the delay was constitute an unlawful refusal, and the delay, if there is a delay, it was only because the city was maintaining a lawful legal basis, as argued in the court, to substantiate its position. And again, once that position was questioned by Judge Raboul, it was promptly turned over at no cost, I must say. Again, the evidence shows, to Dr. McDonough shortly thereafter. I do want to take it next to the hang on 1 second, to the next issue, and the only other issue to be tried today that was again framed by Judge Ruiz Cohen, and with respect to plaintiff's claims relating to request number 5, the motion is denied, as there are genuine issue of facts as to whether these records have been turned over. The court shall have a hearing to determine whether the delay in providing documents responsive to request number 5 constitutes an unlawful refusal and entitlement as to an award of costs. Now, it's our position that there were no documents that were responsive to his ultimate request that had been narrowed. His initial request, as we talked about before, his initial request was an extremely broad request. And again, it was, and Plaintiff's Exhibit 1. Excuse me, I'm sorry, not Plaintiff's Exhibit 1. I take that back. It was Plaintiff's Exhibit 12. And it's important to note that his request, copies of documents and records relating to Homestead Police Department's Facebook page, it is not a qualified, limited request. It is an extremely broad request that he made. Basically, everything and anything under the moon that relates to the Homestead Police Department's Facebook page. So it was very broad. The city construed it as a very broad request. And in the dialogue between the city and Dr. McDonough relating to that request, which is it's Plaintiff Exhibit 14 and City Exhibit C, that's been admitted to evidence, and I asked the court, we can go through it, but I think it's very telling. The court can go through the dialogue. It will show that Dr. McDonough balked, and I understand why. It's a very large request, very broad request. It was a huge deposit that was asked by the city, and he balked at it. And it's like, I don't want 53,000 pages. And there was various dialogue between the city's counsel, Mr. Zeskind, and Dr. McDonough. And hang on, let me pull up the exhibit. And Mr. Zeskind clearly said on June 2nd, you requested without any time or other limitation copies of documents and records related. That's the words, the verbiage that he used in his request, related to the department's Facebook page. And he says the city has approximately 53,000 records responsive to that request. And as a result, you receive the attached invoice in response to your request. And this is where Mr. Zeskind said to him, we'll work with you if you want to narrow it. If you want to narrow the scope of your request for documents, the city will work with you to provide you with a response and new estimate if a deposit is necessary. And then there's dialogue back and forth. This is on June 1st with Dr. McDonough on June 2nd. Says, again, there are not 53,000 responsive documents because I didn't ask for any such record. And he says, if there are no records to be requested in my questions, that's fine. It would be expected that there would be at least a records for the policy for deleting comments and blocking people from commenting on the Facebook pages, or who has such authority to make such good determinations. A record of log deletion. And let's see, then he follows up with another email. And then Mr. Zeskind responds back. It seems that you misunderstood my email, did not state the city's maintaining the records. To the contrary, you've been advised now on multiple occasions, the city has in fact over 53,000 records. The city's made those records available upon your advanced payment of your deposit. And again, the rest are questions. Then the last email in the chain, which is the most important email, is where he limits his request. If you have records on Facebook, I would like the destruction logs for the deletions of my comments. And I would also like a copy of the policy. I did not ask for, nor do I want, a copy of the 53,000 Facebook posts. So he is basically disclaiming and saying, I don't want what was initially asked for, so that's too broad, but what I want are the destruction logs, and what I want is the policy. That's the only thing that's in play. He has not asked for a document showing who the administrator is. I know Your Honor had asked some questions. Well, he asked a question, or he may have asked who is the administrator under 119.
Mr. McDonough, you're going to be given a chance at rebuttal, but allow Mr. Mandel to continue with his argument.
He did not ask for a specific all documents relating to the administration or who the administrator is. Again, it's narrowed. It's not a new request. It's a narrowed down request because there's the dialogue about this request number 5. And he's basically saying, all I want is the destruction logs and all I want is the policy, nothing more. So to that, and this was on June 2nd of 2015, as Your Honor could see from the email. Then Exhibit E, which is now admitted into evidence, which was less than 2 weeks later, Elizabeth Sewell, the city clerk, responds back to him again with respect to the destruction logs, don't have any, and the policy. We don't have a policy. This request is done. He narrowed it. We responded. We don't have the documents. There should be no more litigation or labor as it relates to this issue. Your Honor, this case has been going on a long time, and I know you're coming in as I think maybe the 4th judge on it, but it's basically been wrapped up, it's finished, and we asked that in light of the evidence today in this proceeding that it finally be put to bed and that we can then move on. Thank you.
Okay, thank you, Mr. Mandel. All right, and Mr. McDonough, you have reserved some rebuttal, and I'll let you.
I just have a few points. First, I highly take issue with Mr. Mandel's interpretation of those emails. Those emails speak for themselves. I never stated I was narrowing my request. I never stated I was waiving any part of my request. Furthermore, as evidenced by Mr. Mandel's argument, it's clear that the city did not properly interpret my request. Mr. Mandel and Mr. Zeskine continue to focus on the first line of the request. There's 6 lines. That's, I don't know, 84% of the request has been completely ignored there, Your Honor. So I want to make that very clear. I never waived the request. I never narrowed the request. Just because I said, hey, I expect that you would at least have this, or hey, if you have this, I want this, is not me waiving anything else that I have a right to. So I'll leave that point with that, and I'll go to my next points. Whether we're going to address the unlawful actions of the city here based on excessive cost or improper redaction or undue delay, we get to the same point. At least with requests 4 and 6, the city has a burden to prove it has a right to an exemption. City has not met the burden to prove it has a right to an exemption. The Florida Records Law is clear that all exemptions must be narrowly construed to exactly what they are. And so if the city delayed giving me the request giving me the videos by 2 years or 4 years because they made an improper interpretation of the law, that's still an unlawful refusal. And while the city's policy on whether it redacts uniformed officers or not may have changed over time, the exemption here did not change, Your Honor. The exemption is exactly the same. Further, bad faith is not required to find the records were unlawfully delayed or unlawfully withheld. It doesn't matter if the city acted in the best faith possible. If they violated the letter of the law, it's an unlawful refusal, and I'm entitled to cost. And Again, the city just continues to misconstrue my request 5 and ignores the majority of request 5. And that's all I have, Your Honor. Thank you for your time.
Okay. All right. Thank you. Thank you. All right. Okay. So issuing my ruling, I'm going to
Your Honor, before you rule, can I ask Council Mandel, is all your exhibits in evidence, sir?
The only additional exhibit, other than Madam Clerk, the stipulated exhibits that we added was City Exhibit E.
So all of them are in evidence. That's what I'm
Um,
asking.
are all of my exhibits in evidence?
Yes, that's what I'm asking.
No.
You have from A to L.
A, B, C is in evidence. D is not. E, F, G, H, I, and J are in evidence. And exhibits K and L, which are requests for admissions and the response to requests for admissions, those have been filed. Those are part of the court record. So those were not entered in as evidence, but those are part of the court record.
Okay, so for clarification, you have D, K, and L. Those are not in evidence. The rest are in evidence. Okay, thank you.
Correct.
Okay.
Thank you, Judge.
All right. Thank you, Alba. Okay. So I'm going to rule now, and I've made some notes, so bear with me. I'm going to start with regards to request number 4 and number 6, which really comes down to, it is a matter of statutory interpretation, which is an extremely difficult subject. So much so that our own late Supreme Court Justice Antonin Scalia wrote an entire book on the subject called Reading Law, and it was all of 600 pages. But one of the important takeaways from his book was the concept of reading statutes in pari materia, which is Latin, and as part of the whole. And in that chapter, he discusses that it wouldn't make sense to read a statute and to get an unreasonable result. This particular statute has a troubling component. On the one hand, it makes it an exemption to have identifying information on police officers, and it excludes photo. It makes no mention of videos. I would be reading the statute. He would absolutely conclude that the word photograph should be interpreted to mean image, because it wouldn't make sense otherwise. And I know that my colleague, Judge Rabul, took a different approach, which was more of a strict interpretation approach. And I don't quibble with that. Under the strict interpretation approach, he looked at the word photo, and he, concluded that the legislature, in using photo and not photo, comma, video, etc., was intended on somehow exempting photos but not videos. I am not here I'm not going to say whether Judge Rabul's interpretation is reasonable or not. However, I will only say that the city of Homestead, in its initial redaction or claiming exemption on the video, did not act unreasonably. And I would repeat that if Justice Scalia was alive today and were looking at the way that 119 is written, he would certainly find that you cannot do statutory interpretation in a vacuum, that you would have to read that it makes identifying information exemptable, it would not make sense for videos to then not be exempted. So I'm going to find that there was no willful, unreasonable conduct on the part of City of Homestead in that regard. And that when Judge Rabul handed down his ruling, they complied almost 2 months. I think it was a week or a month and 3 weeks from the time that his order was handed down, with the entire video request that was made. And I'm not going to find that this was an unreasonable delay. There was no, at this point, they turned it over without an invoice to Dr. McDonough. So he did not incur any costs as associated with that. I did make a note, however, that he did pay $91 for one of the, and I think that, I'm not sure because there was two different invoices, but I know that that particular invoice, the one that was $91, is one that he did pay, and that they did not waive, or it doesn't show that they waived the 30 minutes, the first 30 minutes of the request. So as to that portion, as to that invoice of $91 that Dr. McDonough paid, I'm going to find that the City of Homestead does require to refund him $22 on because it's that would, or half of, I'm sorry, half of $22. It's $22 an hour was the fee that they were charging. And since they did not deduct that first half hour, then he is entitled to half of that fee. So, roughly $11 on that. And then moving on to the Facebook request. The initial request made by Dr. McDonough certainly gave the impression that Dr. McDonough was asking for everything except the kitchen sink. It was, extremely, I understand why the police department, upon reading it, was under the impression that they needed to turn over all of the Facebook postings. And I don't find that submitting the invoice for what they believe he requested was unreasonable. Now, after that, there were email exchanges going back and forth in which, Dr. McDonough made it clear to the City of Homestead that he, in fact, was not interested in having all of these copies of all the postings on Facebook, but rather he wanted some specific information, and that information was how things get deleted or taken down, and things of that nature in regards to that. And he did receive responses to that. Now, there was a request made. Of course, it was made in an improper form. Answering. Of course, when you ask for when a public record request is made, it's a request for documents. Okay. In the case of the Facebook, the way it was worded, the response was, okay, he wants a copy of all of the Facebook postings, which was a reasonable interpretation of that request, which is why they compiled and said, well, this is going to be $5,000 dollars for all of these Facebook postings. With regards to the request which starts with the word who I forgot if it said who is in charge of posting or who I don't know what the question was exactly, but I do remember that it started with the question who. That was a question that was not answered directly, and it was not mentioned when the emails were going back and forth to try to get Mr. McDonough the information, to narrow down the information that he was requested. So I'm going to find that although the question wasn't answered, and that Mr. McDonough, that the city did not behave unreasonably, because there's no reason for the court to believe that had Mr. McDonough, in his many reply emails had said, hey, oh, and by the way, I still haven't gotten the answer to the question of who is responsible for posting the Facebook. I have no reason to believe that this was a willful denial of a request, but rather that, since it wasn't brought up again, that it the request was waived, or at this point treated as waived by the city of Homestead. And so I am not going to find that there was willfulness, that there was some sort of insidious or bad intent in withholding secret information, or information that the police department did not want to give to Dr. Dono, or that that it was somehow keeping requested, willfully withholding requested information. So that is it. Those are my findings. So I only am going to find that as far as the doctor's costs, that he be refunded for that portion for the public records request that he did pay for, the $91, that he get refunded for that half hour, and that takes care of it. And this matter hopefully will now be concluded.
Your Honor, with respect to my cost of enforcement, like my filing fee, and are you making a determination on my cost?
I am going to leave those for another day. At this point in time, I'm going to make my ruling as to whether or not there was a compliance, and I am going to leave for another day. I'm sure that the city of Homestead also has motions for their fees, so I think it would make more sense to have those in a separate fee hearing, a fee and cost hearing, separate from today's hearing.
Your Honor,
So so to answer your question, I am deferring ruling on that.
How would you like
purposes of the order, I'm sorry, Dr. McDonough. Purposes of the order, I can, if you want, I can try to take the lead on taking a shot at the order. And just as it relates to the issue about, I'll call it the $11 issue, that, if I understand Your Honor's last statement, that will be something that we'll look at when we're dealing with the cost issue. So for purposes of your order, your final order will just be as to whether or not the city unreasonably withheld documents on 4
No,
5
it's no. I'm just I'm making a finding that because I know that Mr. McDonough, Dr. McDonough did mention being overcharged, and I wanted to make clear that was the only instance where I found he may have been overcharged, because the other, ultimately, he did receive all of the other requests free of charge, as I understand it. The only invoice that he paid was the $91. So any kind of overcharging on the part of the city of Homestead was only as it relates to that initial half hour for the invoice that he paid, because all of the other invoices were not paid, as I understood the evidence.
Understood, Your Honor. Do you want that to be part of the order for today, or for the matter that the cost matter that you're going to hear at another point in the future? That's my only question.
Um, I part of today's hearing that Dr. McDonough wanted the court to rule on whether or not the city of Homestead had complied with request and overcharged. I did make a legal determination, a legal ruling on that, so I do believe it should be included as part of the order. That was the only possible overcharging on the part of the city of Homestead.
In Your Honor, is this going to be considered a final order, or will the final order come after we have the hearing for fees and costs?
Well, this will be a final order.
Okay.
A motion to then for attorneys' fees and costs will be made and will be heard at a future. But ordinarily, this is a final appealable order.
Okay.
Yeah, it is.
Thank you.
Okay. Thank you.
Have a great weekend.
You too. Have a great day, everybody.